Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Apologies, a couple minutes late. We've run over time on the pre-show just about every day this past week. But let's start off with Judge Glazer, Miami-Dade.
$4,001. Can she afford that?
Yes, Judge. She'll be fine with that.
All right. Good luck to you, ma'am.
Thank you, Judge. And if we can address the other one, it
Yes,
was the.
ma'am. I have it next. Just be patient, please.
Sorry, Judge.
Next up, page 14, Andres Restrepo.
Interpreter, please.
Interpreter is present. Thank you.
Good morning, sir. You were arrested for sale of possession with intent to sell cannabis within 1,000 feet of a school.
Está usted acusado de intento de venta aproximadamente a 1,000 pies de una escuela.
Possession of a controlled substance, THC vapes and gummies.
Y también posesión de una sustancia controlada, que era el THC, con el vape y también los gummies.
All right, possession of drug paraphernalia and public nuisance.
Y también posesión de parafernalia de drogas y también de molestar al público.
So I will appoint the public defender's office for you.
Le voy a asignar
I'm
los
sorry,
abogados de
not
oficio.
Petey. Your lawyer's here. Pardon me. Miss Gonzalez Petrovic is here for your private lawyer.
Es mejor dicho, la abogada privada, su abogada y la señora González Petrovic está aquí para representar.
Okay, he's the manager of the business, so it's a little different than the other person who was working there.
Este es un poco distinto porque él es el gerente del negocio
There's probable cause for the charges.
y hay motivos fundados para las acusaciones.
All right, count one, sale of cannabis within 1,000 feet of a school.
Entonces, en la primera acusación
That's $5,000.
va a ser $5,000.
Count two, possession of the THC vape and gummies would be $1,000.
Y en la posesión de THC y los gummies y el vape son $1,000.
Possession of the drug paraphernalia is $500.
Y también por poseer parafernalia de drogas son $500.
Count four, the public nuisance.
Y
I'm
también por
setting
ser
that at $500.
y por molestar al público sería $500.
You have a good lawyer, listen to what she tells you. Thank you so much for coming in, Ms. Petrovic.
Thank you.
Tiene
Have a
una
nice
buena
day.
abogada, por favor, póngale atención.
Okay, next is Deonta Naren. Is that here for a victim? Okay. One second. All right, good morning. This is Mr. I'm sorry. Deontaneri. Sir, you were arrested for burglary with an assault or battery. Can you afford to hire a private lawyer?
Yes.
You want me to reset this case for you to have a lawyer come to court?
Is it necessary?
The state's filing a motion for pretrial detention to hold you at no bond. Are you working?
Yes.
How much you make a week?
Around after taxes, probably around 600.
Do you
I
have
can
any
afford-
children you support?
Yes. I have a question. Is it?
How many children do you support?
I want to have a daughter.
One daughter, Judge.
I mean, you said you wanted me to appoint the public defender's office for you. I will do that
No,
since I think
No,
you'd
I have a
qualify.
lawyer.
You have a lawyer?
Yes,
Oh,
ma'am.
who's your lawyer?
Luke Newman. Also,
Who is it?
Mr. Luke Newman. But
Luke
my
Newman is his
he's-
attorney.
I'm trying
Okay.
to inform you is I believe I was supposed to have another one. Is my brother was trying to get it from me this morning.
And his
Oh.
brother was getting a different lawyer.
The female that's on the case, Hamani Asunder, I believe she's supposed to be here today.
She's here in court. I have the victim in court, but I don't have a lawyer here. Ma'am, you raise your right hand to be sworn, please.
Me? Stop.
Well,
I do.
all right, what is your name, please?
Hamani and Cinder.
All right, Ms. Alcindor, are you afraid of Mr. Naren?
No.
Was that a no?
Correct.
Okay. So, do you want him to stay away from you?
Did we swear her in or?
Yes, the clerk swore her in.
Okay, apologies, Judge. I
You didn't hear? No, you didn't hear. So, excuse me, Eric, when you swear in the witnesses, you have to turn on your microphone there because they couldn't hear you. Thank you for letting me know. Okay, he was sworn in.
Thank you, Judge.
All right, has anybody forced you or threatened you to come to court today?
No.
All right, thank you. State, do you have any questions for Ms. Elsinder?
I do not, Your Honor.
Defense, and I'm sorry, you don't have a lawyer here, so I'll have to reset it for the lawyer, okay?
Wait,
What would it be?
what does that mean?
Huh? Well,
This afternoon?
tomorrow, this afternoon, but the state filed a motion for pretrial detention pending final hearing because they want him held with no bond. I need a review for probable cause.
So I'm not gonna be able to bond out now.
This, okay. I may give him a bond. She doesn't want to press charges. She told that to the police. Sir, I'm gonna enter a modified stay away order from the alleged victim whose initials are HAA. You are allowed to have contact with the alleged victim. You are prohibited from being physically threatening or violent towards her in any manner whatsoever. Do not engage in any criminal activity, do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the modified stay away order?
Yes, ma'am.
Okay. So your lawyer's not present. You want me to wait? You want to waive his presence for purposes of this hearing? You want me to reset it in the afternoon?
No, I don't want to reset it.
Okay. You want to waive the lawyer's presence?
Yes.
Okay. What?
Yeah. Yes, ma'am.
Okay. I'm denying the state's motion for pretrial detention. I'll set a bond. $5,000.
That would be overstate's objection, Your Honor.
So noted. Now, even though I'm setting a bond, the state may still want to go forward with the motion for pretrial detention. And they can always, and then you would lose your bond if the judge does decide to take you into custody. I just want you to be aware of that. Okay?
Yes, ma'am.
All right. Thank you. Have a nice day.
Good morning once again, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. We're going to go over to Judge McNally. If you look on the left side of the screen there, the guy in the red jacket, that is Hoarder Man. So he will be up to bat here soon. But in the meantime, let's see what's going on with this guy at the podium.
Video. No, not on Zoom.
Zoom. All right.
Today is the date and time set for sentencing. We have had an opportunity to review the pre-sentence investigation report. We would like to announce that there are no deletions, corrections, errors, or omissions. Moreover, Judge, we're asking the court to adopt the recommendation on its face. There appears to be another program I'm not used to seeing under provision 6, and I will leave that on faith. I may just briefly speak on behalf of my client. Thank you. First of all, Mr. Caldwell has, according to our records, has no marked past criminal conviction history. Moreover, he appears to be a recreational drinker without any marked history of blackouts, violence, or treatment. In my opinion, Mr. Caldwell made a foolish decision this evening to hang out at the Sterling State Park and consume the amount of alcohol that he did. He was a .152. There's an accident, there's a correlation, and he is very remorseful. He is very concerned about what happened, and he's taking this very seriously. And he's hoping that his employer is not going to, after 9 years of employment here as a press operator, is not going to terminate him from employment. He is on a restricted license right now with Secretary of State under the G25. And I feel that he's a candidate that will be able to get through the probationary process successfully. He does have 1 day jail credit. I did see that he is going to AA. He has a sign-in sheet as part of his bond conditions, but moreover, he's enjoying being there. There are people there that he is interacting with, and it seems to be very helpful for him to continue moving on towards his sobriety. I have nothing else to add.
Sir, is there anything?
I apologize, I didn't see it. I shouldn't have done what I done.
I'm sorry?
I shouldn't have done what I done.
Yeah, I mean, I have some real concerns here. You crossed the center line. It sounds like, from my reading of the report, that had the victim not swerved, which just resulted in a sideswipe, that this would have been a head-on collision. Then you left the scene. Not good. 12 months probation. This is on the operating while impaired. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, home telephone number, you must notify probation. You have to report as directed, no alcohol, no marijuana, no drugs of any kind unless prescribed by a physician. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you submit the chemical testing, PBTs and ETGs. It's going to be bi-weekly for 2 months. If you're clean, I'll make it monthly then. Restitution, if any, will be handled through civil litigation. You're not to have any contact with the victim at all. No contact with the victim, Jackson Carmona. Not write, phone, see, text, or communicate with him or have anybody else do any of those things for you on your behalf. Also, I want you to continue attending AA once a week until you're in outpatient. Yeah, I'm going to order outpatient treatment, not the Class A substance abuse.
You're going to strike 6?
And I'm having outpatient instead. You're to go once a week until in outpatient. Once you get in outpatient treatment, you no longer have to attend AA or NA. You also have to attend the Victims Impact Panel that is one night put on by Mothers Against Drunk Drivers. You're to serve 4 days jail credit, 1 served 3 2 days will be on the court work program. There's a $35 a day charge for that. And the other day, I'll let you serve by way of community service. You have to serve 8 hours of community service at any nonprofit organization of your choosing. You get probation will give you some ideas, but Church, Salvation Army, St. Vincent de Paul, and animal shelter, I could care less. Habitat for Humanity just has to be nonprofit. You have to have that done by October 31. We will schedule you 2 days on the court work program. As I said, there's a $35 a day charge for that for a total of 7. Again, this is all on the impaired charge. 300 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 6 1/4. Screening fee is 60 for 685. You have probation fees of 240. Bring your total to 925. Attorney fees, $40, 965. You have cost of recovery of 150, bringing your total to 1115, plus the court work program fees. Your total amounts to 1185. If you violate your probation revoked, you could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer. If you do everything, you'll be eligible for early discharge 6 months after. So 6 months into probation, if you've been compliant with everything. So if you violate, like I said, you could get 93 days, but after 6 months, if there's no violation within the preceding 90 days, you're eligible for early discharge. On the failure to report a property damage action, 100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 4 days jail credit, 1 serve 3, and I'll let you serve those again. 1 day community service to be completed, like I said, by October 31. And then 2 days court work program. So it's 4 1/4. Those will run concurrent. Do all of that, then, and you'd only have to do 2 days court work altogether, not 4, and not 2 days community service. You do all that, and you'll be done with that case. So you have to pay 4 1/4 on that one. Plus the 1185, so you owe the court $1,610. Can you pay all that today?
I have 1,000 on me.
Okay, so why don't you do this? You pay the failure to report today, that's 4 1/4. You pay $575 on the operating while impaired.
Does he have a personal bond here?
Yes. How much can you afford to pay per week or bi-weekly?
I can at least do 250 a week.
I don't really need you to do that. Let's make it $100 per week. If you want to pay more, that's up to you. We'll make your first payment due on October the 6th, okay?
Can I pay this week or this account?
Yes, you can pay as soon
You
as you.
just have to stay in.
And I have a question. Can I just call in or do I?
You're gonna-
Call in and pay over the phone? Or
Go to 33court.com.
If you pay a credit card when you're paying something other than the balance, there's a small fee for that.
oh, okay.
And they'll explain that to you up at the top. If you bring it in and pay by cash or check, there's no fee.
That was another question I was gonna ask. We already took care of that. I had cash on me.
Okay. All right, you're all set. And make sure you meet with probation. Good luck.
Just real quick, the Roseville prosecutor has a question for you.
Okay?
So
Wait,
he's gonna go to the probation department.
so go down and pay first,
And then go.
and then you're gonna go over to probation.
Okay, you got you. Okay.
Okay?
Thank you.
All right, best of luck.
Good morning, Your Honor.
Good morning. What, do I need to call a case?
No, Your Honor, I just said a quick question. I'm just trying to help the court out here. One of the defendants of the township, the individual, last name is Pfeiffer. He is here in person. His attorney is on, so the defendant is being arraigned today. He has a pretrial. The defense counsel said that he was unaware.
Where's defense counsel at?
He's on Zoom.
I know, but where's his office?
I believe it's lined up.
Who's the lawyer?
RV. Yeah, RVE.
What, are you just asking to pre-try it by phone?
Yes, just, well, not
And then-
necessarily pretrial, just for the arraignment portion. I think that was more important.
Well,
I'm sure it's okay with the court that it was bifurcated, that he
he's
is.
gonna have to be here from now on, you tell him.
Yes.
Or his client has to be in his office.
Yes, I'll get it on there.
And then, but for today, you can go ahead and pre-try it with them. And then we'll go on Zoom and I'll arraign them and pre-try it at the same time.
Yes, Your Honor.
Makes sense?
Yes.
Okay, okay, thanks. All right, Giles. Alyssa Diane Giles, 25I 414-960 A and B. Your name, ma'am? Boy, okay. What were you doing? You got you running the stop sign and,
Wait, well, my sister's birthday party.
all right, so you're gonna plead to impeding traffic. They're going to dismiss the speed and the stop sign, right? Okay, to that charge of impeding traffic, responsible or not responsible? All right, I'm gonna accept the plea. 160 is your total, and I'm dismissing the speeding and dismissing the stop sign, okay? All right, how was the birthday party?
It was good.
Have a good day. Thank you. Whoever has the phone in here,
Oh, we gotta call her back.
you're probably gonna be on the, talking with a cell phone next time too, right? All right, I'm just kidding. Matthew Glenn Malone. 25B148493. I also have 25B148976.
Thank you, Your Honor. For the record, good morning, Council Attorney Mike Baldwin on behalf of Mr. Sir, can you just state your name for the record, back and on. Judge, today's the date and time set for a pretrial. We've worked out a resolution.
There's going to be a dismissal on file 493. That's the May 26, 25 incident. And then he's going to plead to trespassing under 771.1 for 12 months on the file ending in 976 with an incident dated June 26. True?
Yes.
If you do that, sir, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And did you sign an advice of rights form today?
Yeah, it's on the.
I know. Did you sign it? Did you read it? Did you understand it? If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? All right. To the charge trespassing, how do you plead? On June 26 of 25, were you at 7:22 p.m., were you at 17707 Telegraph near a Mills in Brownstown?
Yeah.
And that's where Tele Valley is, right? And had you been trespassed from there, told not to come back there? And you went on anyway?
If I get something along,
Anybody forced you to plead guilty?
No.
So you went back into the property? All right. Are you on probation or parole?
No.
Anybody forced you to plead guilty?
no, say,
You're doing good. Yeah.
Please accept it. Why do you keep going back there, sir?
I have belongings in there, I have work to do there. And I got kicked out, I have belongings, I stayed with several people on there,
You can't go back, though.
not going back again.
Give me a probation.
Yeah, Crystal told me to stay away from that one. The fire chief then helped me out, they all told me to stay away from the park, I'm staying away from the park.
All right, I'm accepting the plea under 771 on file 8976. I'm dismissing the other file on motion of the prosecutor 25B148493.
You consider a 6-month delay,
You guys agreed to 12, right?
then we will, yeah, it's in.
I mean, I don't care, I'm just not gonna take a plea where they got 12 months. If you want to go talk to her again and say 6 months, that's fine.
Thank you. Well, the understanding that he'd be eligible for 6 if compliant.
Give him a review date for 12 months out.
Yes, Judge.
So if he wants to apply after 6, we're gonna have to set it on a prosecutor date,
Yes.
and then she can move to dismiss.
Yes.
All right, you ready for sentence? I'm not gonna order a pre-sentence report.
Yes, Judge, I thank you very much. Your Honor, it's pretty straightforward. He was notified not to return to the property. There was a trespass notice generated apparently in lien. He was there to gather his possessions. He had some work there. He disregarded the notice, and for that reason, he stands before the court today, and he's been staying out of trouble. So he seems to get the message at this point that he's not to return, and if he does, it's a violation. This would be considered a violation of the delayed sentence, and he could lose that status and end up ultimately taking a criminal conviction on his record and perhaps maybe jail. So he understands the importance of following the court order. Thank you.
Anything you want to say?
No, sir, I won't be back there again.
12 months probation. I'll take it under 771.1. You cannot leave the state without the consent of the court or violate a law. You must appear in court at probation as directed. You're not to attend the Tello Valley Mobile Home Park. If this happens again, we're gonna have issues, okay? All right, you're not to go back there. Fines 100, cost 75, 75 victims' rights fee, $50 justice assessment, 240 in probation fees. Your total's 540. You stay away from there. You stay out of trouble. And the case will be dismissed on motion of the prosecutor in 12 months, okay? If you violate, you're subject to a 90-day jail term. Lisa, what do you have in terms of a?
September
Review.
9th. September
I'm sorry.
9th
September 9th of 26
at 9 o'clock.
at 9 o'clock. Okay? So make sure you put that date in your calendar. You'll have to show up. Can you pay all this today?
Excuse me?
Can you pay all of this money today?
No,
How much do you have today?
I don't have.
Where do you work?
I do odd jobs here and there.
How much, when can you pay this?
They payment plan or
Tell me how much you can pay and when.
$50 a week starting next Friday.
Fine, $50 weekly. I'll start this beginning on October the 6th. How's that?
Sounds good.
If you need more time, call the court. We'll go on Zoom. I'll be glad to give you an extension. Go down the hall, get your notice for that date in September of 26, and then you'll meet with probation. Instruct you, okay?
Told me to be on the 24th at 8:30 a.m. I'm here.
No, it's the 20. It's the,
I know that.
yes. You showed up on your bond.
God bless me.
Appreciate it.
Thank you, sir.
And then we'll do probation right across the hall. I'll take you down. Yep.
All right. I need Miss Foley Carter out here. I'm Robert Boyd. Narian, Razangani, 25B82626. Come on up here, sir. We're gonna have a 4-week adjournment here, Lisa. Your name, sir?
Narayan, then.
Okay, so I want to be clear. I'm gonna give you 4 weeks. That's what the stip says. But you either have to have, it says it's his intention to sell the property, that's fine. But if it's not sold, I expect you to have the rental registration accomplished. Do you understand that? I'm just telling you. Ms. Foley Carter, your name?
Caitlin Foley Carter.
I'll give him his 4 weeks, but this sounds like it's been going around here. Like, let me see here. Failed to register rental property, second ticket.
Right, it's been, 2023 is when the process has been, or the property has been vacant. So my understanding is his intention to sell it. If that's his intention, I'm fine with it, but it needs to get on the market.
I'll adjourn it 4 weeks, Lisa.
You put it in the market.
I don't know what you guys are talking about. That's up to you two. If she's happy, I'm gonna be happy, but you gotta have rental property registered. Give me the date, Lisa.
October 22nd at 8:30.
October 22nd at 8:30 in the morning. You'll go down the hall, sir. You'll get your notice and we'll see you back here then. Any questions?
No, Your Honor.
Good luck. Robert Thomas Boyd, 25B82557.
Ladies and gentlemen, perk up your ears, give your full attention. This is officially the return of Hoarder Man.
Your name?
Robert Thomas Boyd.
Before we go on, I'll be happy to provide you with a lawyer if you want. This is a review hearing.
No, sir.
You waive your right to a lawyer.
I do.
Name?
Caitlin Ford, attorney, Providence Township.
Rob Harris, Inspector, Brown South Township.
Please tell me he did what I told him to do.
As of yesterday at about 2 p.m., no,
Nothing?
nothing. The property looks worse.
You're gonna force me to do something I don't want to do, Mr. Boyd.
I've done a lot of work out there. I've,
Okay, let me just go through this with you then. Okay? I ordered that the garage must be torn down and removed from the property on or before September 15, 25. And the undersurface filled to grade level. Did you do that?
no,
I ordered that all non-permitted accessory structures be removed from the property. Did you do that?
which structure would that be?
Remind me.
It's like the mobile home.
Right.
Use as storage.
Rob was supposed to give me a phone number, a place that takes RV.
Why don't you tell me what you've done? I ordered you to have all vehicles on the property licensed and operable, and that they had to be located on a concrete or asphalt driveway surface. When I read these to you, you can interrupt me. You can stop me and say, Judge, I did that. Did you do that one?
No, sir.
I also said all inoperable vehicles have to be stored inside an enclosed building or removed from the property on or before October 1. Did you do that?
Partially.
I also ordered that all recreational vehicles have to be operable as well as licensed and registered to the owner or occupant of the property. Did you do that?
Yes, sir.
Did he?
I have no proof of that. I've called for inspection, no return call, no nothing, and never.
Recreational vehicles must be stored on hard or pervious concrete, asphalt, permeable grass pavers, or gravel surface. Recreational vehicles have to be used for their intended purpose and not as storage. Winter boat storage is only permitted on residential waterfront surfaces and therefore not permitted at the property. Junk, trash, rubbish, tarps, anything that creates rodent harborage or refuse of any kind needs to be removed. The weeds, grass, and undergrowth must be cut and maintained so as not to be higher than 8 inches. And I also ordered that prior to the review hearing of actually today or September 26th, I said, defendant is to permit Brownstown officials on the property for a compliance inspection. Did you allow them? Did you call there?
Yeah.
Did he call you and he never called you back? Why didn't you do that?
Didn't get it.
Listen, Mr. Boyd,
There are some circumstances here I'd like to tell you about.
Mr. Boyd, I'm going to listen to you. But it's not like this just started. This has been going on for, as I understand it, how long?
Well, there's opens for over a couple of years, and then I took it on like at least 8 months ago.
And the property's getting worse. I went out there. I didn't want to touch anything. I want to listen to what you have to say. I'm going to shut up and let you talk. Tell me whatever you'd like to tell me.
Well, I'm chairman of the Wayne County Canvassing Committee. We had an election. That was 2 weeks. Every day. When you have an election, birthdays don't count, holidays don't count. We have to be there every day for 2 weeks.
When was that?
It was a trying to think of the date.
Well, 2 weeks, but I ordered this.
Yeah, well,
I ordered this back on July 30. This is September. So since July 30, just to do some quick math for you, we've had 32. We've had 56 days. So even if you were tied up in some kind of an election, for 14 of those, you still had 42 days.
Yeah.
What else? What else? I want to listen to your extenuating
I had
circumstances.
a family reunion that was put on me and I didn't know about.
Mr. Boyd,
That was 4 days.
you've had 2 years. The property's junk.
I'm working on it.
No, you're not.
Yes, I am.
That'd be like, no, you're
I
not.
got the boat out for sale up near the road. I got,
Now you're gonna tell me it's bad weather and you can't do this stuff. I don't know what to do with him. I'm gonna be completely candid. I don't know what to do. Because he's not gonna listen. He's not gonna comply with the orders. He's not defiant. No, you're not. No, you're not. You're not gonna comply with orders. You're gonna give me every excuse under the sun. And this can't go on. It just can't go on. And you're gonna force me to put you in jail today. And I don't want to do that.
I don't want to go.
I feel like I've begged you to do these things and you're not doing them. And then last time I got a little more forceful and I ordered you to do it and you haven't done anything.
I'm working as.
No, you're not. No, you're not. Come on. Don't lie to me.
I'm not.
I don't like people that lie to me. I think there's nothing worse than a person that stands in the courtroom and looks a judge in the eye and lies to them. This is, I don't know what to do with you. I don't know what to do with you other than jail you, because I'm not going to get your attention. You're going to give me every excuse in the sun, under the sun. Reunions, elections, 2-week election for a canvas presidency or whatever you.
The election is 14 days.
I just don't know what to do with him anymore. It's fully Carter. Am I supposed to put him in jail or am I supposed to just let him defy orders? That's basically my options here.
I am working on it.
Why didn't you call him back?
Pardon? Oh, I didn't get.
Why didn't you call him back?
I didn't get it. I didn't get his call.
Did you leave a message? When?
It's been probably 3-4 weeks, but I've been out to the property. I mean, I drive by it probably at least twice weekly. There's been no.
I knew this was going to happen.
Well, that'd work.
I knew this was going to happen. I just knew this was going to happen. I was 1000% positive that this is what was going to happen. And I was going to have to sit here now and decide, do I let in gentlemen like Mr. Boyd, and you are a gentleman, defy orders repeatedly? Or do I send you to jail? And I don't think I have an option.
I need more time.
You're going to serve 5 days jail starting today, sir. It's first technical. I'm sorry, that's what I'm doing. Defendant to serve 5 days jail forthwith. And
Hard to do any work from jail.
listen, I'm going to make a promise to you. You do this again, you're going to be sitting in there over Christmas. I promise you. I'm not playing games with you. That's a junkyard. You have neighbors. They don't need to have that blight by their house. My God, who would buy a house anywhere near there? I don't know what else to do. You're in custody for 5 days. Good luck. We're going to set another review. Lisa, give me another review hearing date in a month. If you don't have it done, sir, I'm telling you, bring your toothbrush and 85 pairs of clean underwear. Do we understand one another?
I do.
Good. Okay, new review hearing date, and you're gonna allow him access too the minute he's out. The minute you're out, you answer his phone calls. I'm sorry, Lisa, go ahead.
October 22nd at 8:30.
October 22nd at 8:30.
Yeah, before, can I just double check what Mr. Boyd's phone number is?
What is your phone number, Mr. Boyd?
734-674.
I don't know what else to do.
My concern is, Mr. Boyd's had problems with ordinance since I was in middle school, as far as I'm concerned. This continues to happen. This citation was issued back in April. We've been running around with this. It's not only the neighbors and the blight issue, it's also the dangerousness of the building, especially that garage. He hasn't taken out any permits or anything of that nature, so he's had no intention to comply.
No, I've just heard excuse after excuse.
That happened for me.
And I knew,
Demolition permit, but you have to at least have the building inspector out there to make sure that the structure can come down, if there's electricity there and what the plan is. So you can't just demolish it and have everything sit there. So that you'd have to have a plan at least at minimal, approved by the building inspector for any demolition.
But he told me that.
Mr. Boyd, listen. You brought this on yourself. I don't want to do this.
Yeah, he never informed me about that.
I know, it's their fault. I don't want to hear it.
Okay, guys, let's talk about this one for a second. So, in the chat, seems like most people are in favor of him having been given a few days worth of jail. Our Polish friend Bartos seems to be somewhere in the middle, and our very good friend Bo down in Australia seems to be very much against the idea. Here are my thoughts on it. I agree with what Bo's saying, that there's a mental issue here and all of that. Wholeheartedly, 100% agree. This guy's got problems for sure that need to be sorted out. Two things being true at once, however, the issue that I have is the fact that for 2 years they've been fighting this. There's been order after order. We've seen him at least 2 times, maybe 3. I make so many videos I lose track, and this will certainly be its own video too. But we've seen him at least twice on this matter, and he's been told time and time again, you need to fix this, you need to handle this, and he doesn't. So at some point, the other thing that has to happen is the court has to intervene to, if nothing else, solidify its authority for the benefit of the community. It can't go on being ignored and still have its authority intact within the community that it serves. So while I agree with you, Bo, that this guy needs help, he has a clear mental issue, there's stuff going on, 100% agree. The issue is on the other side, again, 2 things true at once, is that the court can't afford to have its authority undermined by a guy who's just flat ignoring them, whatever the reasons might be behind his ignoring them. Those are my thoughts on it. Let's feel free to continue to debate it in the comments, because that's the one wonderful thing about this community, is that we debate and we discuss, but at the end of the day, we're all friends, and I love you all for it. Let's go to Texas. Judge Stevens.
24 CR 2379, the state of Texas versus Mario Cantu. Judy, that's you, sir?
Yes, sir.
Present with Ms. McNally, your attorney in the state's attorney does. The defendant waive a formal reading of this indictment and arraignment. Can we proceed in summary?
Yes.
In summary, this indictment, sir, alleges that on or about September 30th, 2024 in Jefferson County, Texas, you committed the state jail felony of forgery of a financial instrument. Looks like a United States Treasury note. You understand what you're charged with here?
Yes, sir.
You're lucky the feds didn't get in on this one. Because you don't get deferred or unadjudicated probation in the federal government. You get convicted. You get convicted. If convicted of such a crime, you face any term of not less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
The punishment range is understood. An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years in length. Restitution is owed in the amount of $11,900. Is that your understanding of the agreement?
Correct.
If I follow this, you have no right of appeal of your case. Do you understand it?
Absolutely.
How do you pay back that almost $12,000?
Yeah. I have a job. I have income. So,
How much are you gonna be able to pay monthly?
maybe roughly 75 to 100.
Quicker you pay it back, all things being the same, the quicker I'll dismiss it.
Yes, sir.
Everything else is good. Okay, if I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
You pleading guilty voluntarily and because you are guilty. I show you what's marked as State's Exhibit 1 there, sir. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence without objection. Among other things, this states you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. True. So help you God.
Yes.
State's Exhibit 1. Made a part of the record for all purposes. I'm going to follow this agreement. Anything else to add?
No, Judge, just.
I'll make the findings. Sir, I'm sorry,
We
ma'am.
waive the preceptor.
Okay, thank you. I'm going to make the following findings. You are, sir, pleading guilty voluntarily. You are mentally competent to do so. I make those findings. You are competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence here supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. But I am going to postpone or defer any finding of guilt so long as you follow these terms and conditions of probation, which are normal and customary for this type of offense. You will be on probation for 5 years or less, depending upon how you perform. You must pay restitution to, I presume, the United States government for the amount of $11,900. There will be other terms and conditions of probation, which are normal and customary for this type of offense. And it says you illegally passed this instrument to a complainant, so it must be the complainant who was out the money, not
It's the credit union, Judge.
the credit union. Okay. Well, it says a name of a personal name on this, but we want to make sure that the recipient is the appropriate entity or individual who actually lost the money. And you are going to be ordered to pay. How much did you say you could pay a month?
Roughly 175 to 100.
Okay, I'm going to set the bar at $200 a month. And that's the minimum you must pay.
All right.
There will be other terms and conditions of probation. Make sure you follow them. Okay. If you fail, your probation could be revoked. If you could then be found guilty and sentenced up to 2 years in state jail, and then you got a conviction the rest of your life. But you are a felony, which you don't want. No. Okay. Please see the probation officer. Thank you very much.
All right, let's go back to Judge Glazer. So there's still a lot of good back and forth in the comments about Hoarder Man. I would really like, I think, to talk about that on the pre-show tomorrow, assuming nothing else comes up to preempt it, which, you know, in this world, that kind of stuff happens. But let's do that. Let's discuss that in the pre-show tomorrow. So members, you can hop on stage with me. We can debate it. Bo, I'm going to send you an email because I know you're not a member at the moment, but I'd love you to participate, and I have a way around that. So let's talk about that more tomorrow. Yeah, Judge Glazer, let's see what's going on.
Activity, do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and follow receipt with the court. Sir, do you have to go to the victim's home to collect any of your personal belongings?
She said she was gonna.
Yes or no? You need to go there to get your stuff. or
No,
no?
my auntie, she's gonna give my.
All right, you,
Thanks,
okay,
Judge.
you may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer to retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay-away order, sir?
Yes, Your Honor.
Thank you. So the state filed a motion for pretrial detention pending final hearing. I'm going to grant that motion and hold you with no bond on the charge of attempted felony murder. You will see a judge tomorrow. That judge will set a final hearing on the state's motion, and they can also readdress your bond status at that time. Good day. Next, we have Scott Walker. Good morning, Mr. Walker. Sir, you were arrested for what? So you were arrested for one count of arson in the first degree. Two counts of arson in the first degree. I will appoint the public defender's office for you. So he was told to leave the house. The victim believed he's intentionally set a fire. So he started a fire in the room he was staying at. All right, sir, you were ordered to stay away from the alleged victims, Jose Castillo and Roberto Nunez. No contact with those alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victims through social media or other electronic means, and you must stay at least 500 feet away from the victims, their home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay-away order?
Yes, ma'am.
So the
Absolutely.
state filed a motion for pretrial detention pending final hearing. And because arson, first-degree arson is considered a dangerous crime, I'm granting the state's motion and holding you with no bond on count 1 and no bond on count 2. You'll see a judge tomorrow. That judge will set a final hearing on the state's motion for pretrial detention. That judge can also readdress your bond status at a later time.
Judge,
Have a
I'd
good
ask to
day.
find,
What?
there's only, he's charged with 2 counts. It should only be at best 1.
There are 2 victims.
Given the facts in the case, even if you would take them as all true and assume all assumptions, it should only
There
be.
were 2 victims in the house.
I don't believe that that would change anything, Judge.
State, let me hear from the state. Yeah, maybe you're right. It's one house he's burning, but there were 2 victims.
I'm just gonna look this up, Judge. I believe he's charged with this with 2 counts because of the 2 victims. I'm just seeing if we.
I think they can't charge for each one.
Which I think for purposes of today, I'd ask the court to find probable cause for both, and perhaps it can be readjusted at some point, but for today, I think the court can.
I'd
Fine.
ask for dollar bond account too, Judge.
I'm not doing that. There's two people in the house.
It's
It could be an arson, it could be an attempted murder. Maybe there should be an attempted felony murder for count 2. Because the people were in the house. All right. Count 1 is arson in the first degree. Count 2, there'll be probable cause for attempted felony murder, with arson being the underlying felony. So no bond count 1 and no bond count 2. You'll see the judge tomorrow. Have a good day.
All right, let's change it up a little bit. Stay in Florida, but we're going to go to Wade Mercer and his first appearance this morning.
All right, good morning, everyone. We've got Mr. Riley on my right and my left and your right. Correct, Mr. Riley, you're on your far right, correct? Mr. Riley, yep, there we go. We've got Ms. Jones in the middle, and then we've got Mr. Lee. So I'm seeing at the same time because your cases are identical for first appearance purposes. Each of you are accused of violating the terms of your state probation. Mr. Riley, I'm looking at the warrant in your case. Judge Garcia signed a no bond warrant in your case. Ms. Jones, same thing, no bond warrant. Mr. Lee, same thing, no bond warrant. So what I want to do is I want to get you arraigned this morning. I want to get you a lawyer appointed if you're wanting one, so we can get your case moving. Mr. Lee, would you like to have an attorney appointed to represent you, sir?
Yes.
All right, Mr. Riley, same question.
Yes, sir.
All right, and Ms. Jones, same question.
Yes.
I'm going to appoint the public attorney's office to represent all three of you. Listen to Mr. McDaniel, and then I'll see if you have any questions in just a minute. Mr. McDaniel.
We're going to interplead not guilty. Yes, to set this on October 9th, pre-trial docket, and I advise Mr. Green to come by and visit them prior to that hearing.
October 9th. Mr. Mitchell, anything?
No, Your Honor.
Mr. Lee, any questions, sir?
No, sir.
Mr. Lee, I wish you the best. Mr. Riley, any questions?
No, sir.
Wish you the best, sir. And Ms. Jones, any questions?
No, sir.
All right, wish you the best, ma'am. Next case we have is Rodney Keene. Mr. Keene, you're here because looks like you got first appeared yesterday for some felony charges of some type. We now have a hold from the United States Marshal Service, so just making you aware of that. You still have the right to post bond in your new charges. If you do post bond, you'll be released into the custody of the United States Marshals. If you don't post bond, typically you're going to deal with your local charges first. I have seen the marshals get a order to transport and pick someone up early, but normally the local charges will get resolved first. Any questions?
If I was to bond out and go to the federal,
Correct.
explain all that to you. All right.
Yes, you post bond, you go to their custody. We have Dawson Farmer next. Mr. Farmer, good morning. Mr. Farmer, you're here because you've been accused of one count of reckless driving. Mr. Farmer, the attorneys have done some communication this morning, and I think there might be an agreement to resolve this in a non-criminal matter after looking at the case law that Mr. McDaniel found, as well as the citation, the complaint. Listen to Mr. McDaniel, and we'll see where we stand.
Your Honor, I think Mr. Farmer is going to, the state's going to drop this down, amend this to a careless driving ticket. There'll be a fine associated with it. Mr. Farmer, I think, is going to ask the court for maybe, to either do a class for the points or, or to withhold the points, or at least do some kind of class or something to maybe, lessen the likelihood of any driver's license suspension.
Okay, Mr. Farmer, let me ask you a question.
Yes.
I would not withhold points unless you went to a class because your driving record is not good at all. But have you been to a class? And if so, driver improvement course, if so, how long has it been?
It's been probably about 3 years ago, whenever I caught my first reckless driving. Or DUI.
You did go to a class at that time?
Oh, yes, sir. I went to about 4 or 5 of them.
That's DUI classes.
But it was to get the points taken off the license. Yes.
Okay, so let me ask the question again, because we're talking about two different things. Basic
Yes, sir,
driver improvement. Most of your
Yes, sir.
tickets have points. Listen to me. Most of your tickets have points. So I know you didn't go to class for them because you got points on your license. So my question for you is, how many times have you been to the basic driver improvement course to keep points off your license, if ever?
Just one time.
Okay. In that case, you've got the right to elect to go again. If you want to go, I would withhold the points, provided that you go to a class. Mr. Mitchell, what's the state's position on the transfer if he's entering a plea?
We have no objection to transferring this down to a careless driving citation, and we have no objection to the points being withheld if he attends and completes the driver improvement course.
Ms. Dottie, what's the fine? 163. Mr. Farmer, if you want to do this, I'm going to impose the fine and give you 60 days to complete the class and get the fine paid. The fine is 163. Is that what you want to do, Mr. Farmer?
Yes, sir.
Show a plea of no contest to the civil infraction of careless driving, $163 fine within 60 days, successfully complete a Florida basic driver improvement course within that same 60-day period. Mr. Farmer, if you don't complete the course within 60 days, then what's going to happen is you're going to get points on your license, and your license is going to be suspended until you do complete the course. So you've got to get that done within 60 days. Dottie's going to send something to the jail after first appearance, some paperwork, a disposition. Do you have a civil disposition up here? Okay. So as soon as first appearance is over, we'll get a civil disposition sent to the jail, and you'll be released as long as you have no holds anywhere else. Mr. Farmer, your driving record is not good. You have the right to elect a school. That's why I'm going to withhold the points, because you can make that election. You've got that right. But you've got to do something with your driving pattern, or I'm going to be seeing you again, okay?
Yes, sir.
Have a good day, sir.
Judge, he told me that he didn't get him tickets and they didn't give him any, which I know they're supposed to give them to him if he's going to be getting them, but it's not unheard of that they send in tickets later that they never told him about, never gave him. So maybe the clerk can just watch and see if any tickets come in on him, I guess, or the court wants to, entertain anything if there are, because I think it was alleged that he run a red light, and, not quite sure.
Thank you, Mr. McDaniel. So Dottie, if there are other tickets that come in on him, I need to be made aware of them. If it's related to that incident, everyone knows I'm typically going to make him pay one fine and only one fine. Now, if there's something weird out there, a child not in seatbelt or some horrendous speed, I'll be glad to look at that, but none of that's alleged in the complaint. As far as we know, he didn't write you any he or she didn't write you any civil citations. It's not mentioned at all that he did. So as far as we know, this is it. If you get anything in the mail, you need to contact my office so we can take a look at it, okay?
Yes, sir.
Have a good day. We have Arthur Jenkins next. So is Mr. Mitchell, I'll wait till Mr. McNally gets through and ask him to. Mr. Jenkins, good morning. You're here because you've been accused of one count of aggravated assault with a deadly weapon. Mr. Jenkins, there is probable cause for the charge. Mr. McDaniel and Mr. Mitchell, the complaint says that Mr. Jenkins is on inmate release status with the Florida Department of Corrections. I have never heard of that before. I'm thinking that may be conditional release or what used to be called parole, or if it's an old case, it could actually be parole, but I'm not certain. I'd like to know the answer to that because I don't want to hold him if it's unnecessary.
That's what I'm curious about too.
I don't think, if you're looking at DMV, if you look at the website, sometimes they're wrong, but I don't think he's, have you ever been to prison?
13 years ago.
13 years ago?
Yeah.
Yeah. You're not on parole?
No.
Yeah, it was on bond in May. I don't know what's happened to that case.
What happened to that case in May?
No, sir, not that I know
So, I don't know what, he said, jail told me he was on bond in May. I remember seeing him, so I don't know if that case was resolved or.
I didn't give me no, I didn't.
Corporal, yeah, let's see. There is a 2025. No, that's this case, I believe. 440. There's another 2025 case that's closed. Let's see what that was. Possession of controlled substance, possession of paraphernalia. Let's see if it's the same date of birth. It is the same date of birth, dismissed by the state.
Yes, I don't, I mean, the DOC website sometimes is wrong, you know, so I don't think.
Yeah,
it's
some
gonna
substance on the passenger floorboard. State Attorney's Office determined that was insufficient to charge the passenger. It was dismissed. So that case was dismissed. So Mr. Jenkins, you don't report to any officer, no probation officer, anybody right now. Is that correct?
That's correct, sir.
Okay. Does the Department of Corrections website typically show conditional releases? They do, don't they?
It mainly just calls it inmate release, like.
But it'll show it. So they're not there. He comes up under the section for being released from DOC.
Yeah, that's.
In 2013, but he doesn't come up under current supervision at all. So I'm not sure what made the dispatch think he was. I don't even know what inmate release status is, unless that means recently. Well, no, he could be recently released. He got out in 2013.
Yeah.
All right. So, Mr. Jenkins, based upon your recent arrest that was dismissed, obviously that's a factor. It's been dismissed, so it's not a very significant factor. It's just an arrest. I'm going to set your bond in this case. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Jenkins, I'm going to set your bond at $7,500 cash or surety based on your criminal history. You've got a condition, no contact with alleged victim. You do have the right to post the bond. Be aware that if you are on some type of release that we can't see, such as some type of conditional release from the Department of Corrections or parole, I don't think you are, but if you are, you need to be aware you may be wasting money if you post bond because they may be processing a warrant. As far as I can tell, you're not. I'm just not sure because the officer didn't give us a lot of information or didn't give us a case number, didn't tell us what he meant by inmate release status, whatever that is. So you've got the right to post bond. You'll get to use the phone in a few minutes. You can have no contact with the alleged victim, though. Mr. Jenkins, any questions?
Yes, sir. Is there any, I'm on disability. Is there any way that I could go home and if I have to turn myself back in, can I do that? Because I need to check on my house. It's unsecured. And they came at my house at 12 o'clock last night and I didn't know what was going on. And it just caught me totally off guard. And I ain't nothing secured at my house. And they've been robbing and stealing in that area a whole lot. Lawnmowers and people's stuff.
Yeah. Mr. Jenkins, if you hadn't gone to prison for a homicide, I would consider that, but you've been to prison for a homicide. So that's the bond I'm setting. I'm not going to let you out hoping you come back. You will get to use the phone in a few minutes though, sir. Okay. Ma'am, are you here for a first appearance case?
Yes, sir. Jeffrey Brown.
They would have changed it.
He was next. Jeffrey Brown is next in your relationship, ma'am?
I'm his spouse.
Okay. Are you the alleged victim also?
Yes, sir.
Just wait a second. He'll be up on screen in just a minute.
So Judge, I mean, he's kind of confused on this whole homicide stuff, but I don't think I told him I don't think it's gonna matter anyway, because you don't ever let him.
I didn't.
His was aggravated assault he went to prison for, so I don't know what were the homicide.
The Department of Corrections website shows a homicide or attempted homicide. Is that not correct?
It's attempted homicide.
Oh, it's supposed to be
Attempted
just,
homicide.
they're supposed to have to change it, Your Honor, to aggravated assault for what I understood. And
Yeah,
I don't know if they ever.
What the complaint says and the website says is that you were sent to prison for attempted murder. If that's not accurate, obviously we need to reevaluate your bond. That is one of the factors that I'm considering is your criminal history. Now that was several years ago, but allegedly, you made a comment, allegedly, I'll shoot you like I did your aunt, something to that effect.
Oh,
So
no,
that's
no,
part
I
of the
don't.
bond. So you need to talk to an attorney in private. That's what you need to do, sir, okay? Mr. Brown, State versus Jeffrey Brown. Mr. Brown, you're here because you're accused of 1 count of domestic battery by strangulation and 1 count of aggravated assault. Mr. Brown, there is probable cause for both charges. Mr. McDaniel, Mr. Mitchell, the alleged victim is in the courtroom. Ma'am, do you want to be heard? Come on up here because I want to make sure that they can hear you at the jail. So the microphone is up here. And your name, ma'am?
Lori Brown.
All right, Ms. Brown, anything you want to tell me about the situation? I'm glad to listen.
Yeah, Jeff, he has a severe alcohol problem. And when he drinks like he does, he gets to, it's like Dr. Jekyll and Mr. Hyde. He gets very violent and he can't control it. I had to have him committed one time to Emerald Coast to get help. And after that, he did very good. And yeah, I am scared of him, but he needs help.
Okay, tell me about the living situation. Where are you living in relation? Are you living somewhere separate?
No, we live together.
Okay, so there's going to be a condition of no contact. Your intent is to stay in the family
Yeah.
home, at least for the time being, correct?
Yes, sir.
Okay. Anything else you want to let us know?
No, that's it.
Right.
Just, I need to get him help.
He's entitled to a bond, as far as I can tell. I'm going to set him a bond. But
Okay.
there's going to be a condition of no contact. There's also going to be a condition of no alcohol,
All right.
most likely. Okay.
Okay, thank you.
Thank you, ma'am. Mr. McDaniel, anything on behalf of Mr. Brown?
No, Your Honor.
Mr. Mitchell?
Just that we also request no alcohol.
Thank you. Mr. Brown, I'm gonna set your bond at $5,000 on each count. Your total bond is $10,000. You have the standard conditions of every bond, plus you have two special conditions. One is no contact with Miss Brown. That's no contact at all. That's a temporary condition. If you and she want contact in the future, we'll cross that bridge, but for the time being, no contact. You also have a condition not to possess or consume alcohol. Now, that's not because Miss Brown's requesting that, although that's important. The reason I had that written down before she ever showed up is because the complaint alleges there was alcohol involved in one or both incidents. So the complaint mentions alcohol. I put that condition on there. So don't blame it on her, blame it on me. But you cannot possess or consume alcohol. If you get caught possessing or consuming alcohol while this case is pending, that will violate your bond, and I would be glad to sign a no bond warrant. So you just got to stay away from alcohol, Mr. Brown. You'll get to use the phone in a few minutes, sir, to try to post the bond. Mr. Brown, do you have any questions?
No questions, Your Honor. Thank you.
Thank you. Thank you for coming, ma'am. If he contacts you, ma'am, you need to contact law enforcement. There's a condition of no contact, okay? We have one more case. This is a comeback from yesterday, and that is
Nathan Kroger.
Nathan Kroger.
Yes, Your Honor.
Mr. Kroger, good morning. Mr. Kroger, you were first appeared yesterday on two charges. I believe they were driving while license suspended or revoked knowingly and possession of drug paraphernalia. Mr. Kroger, I'm going to tell you, I read the complaint. Actually, the judge already found probable cause yesterday, so you were just brought back today to see if we could get them resolved. It looks like you got out of jail fairly recently, Mr. Kroger, so that's one of the factors that went into the offer being made to you. I'm going to appoint this public defender's officer to represent you today. I'm going to ask that you listen to Mr. McDaniel, and we'll see if you have any questions.
Your Honor, I spoke to Mr. Kroger. At this point in time, he's going to plea of no contest to the charges as listed. You understanding he'll be sentenced 30 days in jail. He had 2 days jail credit, $400 fine. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Mr. Mitchell.
That is agreeable with the state, Your Honor.
Mr. Kroger, did you hear that agreement?
Yes, sir.
Any questions about that agreement?
No, sir.
And is that the plea you would like to enter?
Yes, sir.
Mr. Kroger, I'm going to accept your plea of no contest to the charges of possession of drug paraphernalia, and I'm going to need a disposition, don't I? Driving while license suspended or revoked. I'm going to adjudicate you guilty of those two offenses, sentence you to 30 days in jail, give you credit for 2 days you've already served, impose court costs and fines of $400. That'll be on the driving offense. Waive the court costs and fines on the paraphernalia offense. Mr. Kroger, it appears to me that, you know, the allegation is you had a pipe with some kind of methamphetamine substance. It appears to me you might be a candidate to do this sentence in an inpatient drug treatment center, but it's a really short sentence. If that's something that interests you, let the jail know that they have some short-term programs. So if you want to do this somewhere else, I don't mind considering that. Obviously, I would get input from Mr. Mitchell. If you'd like to do this sentence there, they may even find you a 60-day program. You'd have to complete the program. But if that's something that interests you, talk to the jail staff, and they'll let you put you in contact with one of the drug counselors out there. Mr. Kroger, do you have any questions?
No, sir.
All right, wish you the best. Mr. McDaniel, that's everything I had on my list for first appearances. Anything else from the clerk defender's office?
All right, as he's wrapping things up, Judge Simpson just came online a few minutes ago, so we're going to go to that. An update for those of you who were with us for the pre-show, where we covered the shooting this morning in Dallas at the ICE facility. 2 detainees are dead, and 1 is injured. That's where that stands right now, and the shooter killed himself. So that's the current update on that. Again, let's go to Judge Simpson.
Court does call the case of the People versus Vincent Dunlap. Good morning.
Good morning. Good morning, yeah. Good to see you too, yeah.
Wow. All right. Mr. Bird. Yes, you know that. All right, Mr. Bird, do you have a client?
Unfortunately, no, Your Honor. I did try and call him at his last working number. Madam Clerk did inform me that he was trying to contact the clerks earlier this morning, but unfortunately, he's not here.
I'll tell you what I'm going to do, Mr. Bird, because I'm going to adjourn this. Given the nature of the sentence, I'm not going to bench one. And that there's been some contact. I'll just adjourn this out to our next day. I'll adjourn this to October 8th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome.
Your Honor.
Say I didn't do anything nice.
Never again, Your Honor.
All right.
You and Your Honor, go have a great day.
You do the same, sir.
Thank you.
Court calls the case People versus Kyle Beckerman. Go ahead, Mr. Burgess.
Good, thank you, Your Honor. Good morning. May it please this honorable court, David Burgess on behalf of Kyle Beckerman. Judge, apologize, I had a logistical issue this morning with my associate, so.
That's fine. Your name, sir?
My name's Kyle Beckerman.
All right. Go ahead, sir. This is a date and time set for sentencing.
Your Honor, I've reviewed the pre-sentence report. It is accurate. Understand that the recommendation was for a year in the county. Based on the charge, it was a misdemeanor plea to use of cocaine, Your Honor. And last time we were in court, we were trying to get my client into inpatient treatment. And I believe the court allowed him to be referred. But I'm asking the court to consider either releasing him to treatment or giving him a time served sentence, Judge. I know he doesn't have any means right now. He's homeless. This is somewhat of a victimless crime, Judge. So I'm asking the court to consider a time served sentence or at least release him to an inpatient treatment so that he can get some help for the issue, the substance abuse issues.
Just clear.
Yes, Teresa Claire on behalf of probation. Your Honor, if the court is to consider a release to treatment, then probation would obviously have a different recommendation. There would be probation, a probation term that is recommended. So that could be monitored. When I met with Mr. Beckerman at the jail, he's very adamant with me that he would not comply with terms of probation. Therefore, probation did recommend
Got it. Okay. That's why this sentence is structured in the way. It was based upon the defendant's comments.
Okay, I understand, Your Honor.
All right. Mr. Beckerman, anything you want to say before I close sentence?
I just wanted to apologize to the people, the court. Right now I can't do probation. I'm homeless. I have no income. I really have nowhere to go when I get out, so I don't want to waste the court's time. But I just wanted to apologize to the court and people.
Sentence of the court, $125 statutory fine, 365 days in jail, credit 51, defendant to serve the balance. Thank you.
Yeah.
Thank you.
Thank you. Court calls the case, People versus Christopher Fair.
Under Natalie Pate on behalf of, but I do not with Mr. Fair, Your Honor. Today time set for a violation of probation. He is released from custody, and Mr. Fair and I did speak on the phone yesterday. I do not have an explanation for this hearing.
Teresa Claire on behalf of probation. Your Honor, given that Mr. Fair is scheduled before the court for a violation of probation, he's had multiple failure to appears in the past. And his presence not here today, probation is requesting a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. I'll give 10% privilege on that. That warrant issues immediate. Court does call the case People versus Justin Duffany.
Your Honor, for the record, Walter White with it on behalf of Mr. Duffany. Good morning. Good morning. He and I have had a chance to discuss the pre-sentence report and its recommendations. I don't have any factual corrections to make to the report. A couple of observations. If you look at his criminal history, it looks long and extensive, but if you look at the dates, you realize that except for a traffic ticket last year, his last offense was 13 years ago, 12 years ago, excuse me. Since he's been in jail, he has used the time productively. He's gotten into the Dawn Farms program and also AA on his own initiative. I would ask the court to consider releasing him today and requiring him to find a treatment program. The recommendation is to complete the Dawn Farms program, and I believe that would take him another 3 weeks. But if he could be released today and told to go to another program, I'd appreciate it. I'm sure he would.
Is there anything you want to tell me before I impose sentence?
I just want to apologize for my actions with the bond and that I know that I screwed up. My priorities are in the wrong place. I have taken this time with that trustee and I've been trying to help and better myself. And I promise you I won't be back in here.
Your Honor, if I could just add one more thing. He did have a prison sentence back in the 10, 12 years ago. After he got out in 2017, he completed probation, never tested dirty. So it's not like he's incapable of behaving when it comes to drugs and alcohol. And I just wanted to bring the court's attention to that.
Sentence of the court, 24 months probation. Here to pay $655 fine, court costs, $120 probation oversight fees. That'd be a probation payment plan that's paid by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the in-Dale Dawn Farm program, including all recommended aftercare. You're to attend 2 AANA meetings per week with verification to probation. You're to maintain employment with proof to probation. You're to contact probation within 24 hours of your release from custody and then report as directed. I'm going to follow, I understand what you're saying, Mr. White, but I'm going to follow what probation is indicating. I want him to be able to get a good start because I think he can do it. I'm not really doubting that. He just needs the support around him to get him through.
Thank you, Your Honor.
I think Dawn Farms will do that for him. So I'm going to order 365 days in jail, credit 57 days that he served. He's to remain in custody, complete the Dawn Farm program, and then he will be released, and then the balance will be suspended. Okay, let's get that start for you. What I'm trying to do.
Thank you, Your Honor.
Thank you. Court does call the case People versus Vincent Lambert.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Lambert. Mr. Lambert was transferred from the Washington County Jail to Wayne County Jail. I could not confirm that he is still there, but that is what the jail told me when I went to see him.
Transferred from our jail to Wayne.
Yes.
So you don't know what to do with the case. You're just stuck with me here.
I'm just stuck with you. And without a client. So I'd asked for an adjournment to see if I can hunt him down. If he's still in Wayne County, obviously I'd contact the people to see if we can get a writ. If not, I'll try to get him here, but I haven't been able to have contact with him.
Given the nature of the sentence and what you're indicating, I'll adjourn it out. I won't issue a bench warrant to October 8th, 2025, 9 a.m. Court does call the case of the people versus Sean Costello.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Costello, who stands directly. State name for the record, sir.
Sean Costello?
Thank you, Your Honor. It's my understanding that this is a show cause on the unpaid fines and costs on a closed case, Your Honor.
Is that what this is set for? It is.
So, Your Honor, unfortunately, it was after I left the jail yesterday that I discovered that Mr. Costello was in custody. It is my understanding he's being held on some other misdemeanor cases, with his next court date being October 9th. Given he's being held on those matters and I cannot make payments on the show cause in this closed case, I'd be asking for an adjournment of the show cause, please, Your Honor.
What he's being held on right now are all misdemeanors.
I believe that's what they were when I looked, Your Honor. Yes.
Give me November date. We'll see. All right. I'll adjourn this to November 12th, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you, sir. Court does call the case of people versus Terrence Powell.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Powell. I don't see Mr. Powell here, Your Honor. I did speak with him. He said he has transportation issues. He couldn't get here in person because it is a VOP. Obviously, the Zoom request was rejected. So that is my only explanation for his failure to appear. He would like to request an adjournment so he can get here in person.
And Teresa Claire on behalf of probation, Your Honor, given that it was scheduled for a violation of probation, he is not compliant with his probation terms and he is not present. Probation is requesting a bench warrant.
Bench warrant will issue bond 25,000, 10% privilege. That warrant will issue immediately. Court does call the case of people versus Brian Gerard, all 4 cases.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Gerard. State your name for the record, please.
Brian Gerard?
Thank you.
Your Honor, these are show causes for money owed. Mr. Gerard has been in custody for almost, I think, 200 days at this point.
Gonna be for another 180 days.
His estimated release date in next jail is February. I think February 6th or 8th.
That's my out date?
I think so.
Oh, that's great.
It's February 26th.
I think, I can't remember exact. It's February. I can't remember if it was the 6th or the 8th of February. I think.
That's 2026.
Exactly. Yes.
What's my last date this year?
Can I just pay? Can I just stay here? Just let him pay?
You mean like get
December 22nd?
Yeah.
So here's what I'm going to do. I'm going to adjourn all of these to December 22nd, 2025 at 9 a.m. And Ms. Perrine, what I would suggest that you do is to file the paperwork regarding these fines and costs. It's
Okay.
Going to be there's not going to be necessarily a reason to keep bringing him back.
Okay.
All right.
Thank you.
Thank you, sir. Court does call the case of the people versus. Ahmed Deco.
Good morning, Assistant Public Defender Lauren Perrine on behalf of Mr. Dico. Go state your name for the record, please.
There he is. Got it.
Ahmed Dico.
Your Honor, this is a show cause. Mr. Dico has a balance, I think, around $1,200. I would ask.
I have it at 1443.
Okay. Well, of course, but I would ask Mr. Dico to advise the court what he can pay moving forward, please.
15, same amount.
Say that again, sir.
$15, same amount.
$15?
Yeah,
Why can you only pay $15?
because I'm currently unemployed. I've just been.
You're currently.
Yeah. Can you hear me?
I can hear you. All right, what I'm gonna do is I'm gonna order $25 per month. Beginning October 1st. I'll set a review of his payment. What was my December day?
December 22nd.
Review of payment December 22nd, 2025 at 9 a.m. And his employment should have improved by that point. I expect payments. Thank you.
Thank you.
Court calls case People versus Nicole McCauley. Both cases.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. McCully. Ms. McCully, please say your name for the record.
Nicole McCauley.
Your Honor, we did review the pre-sentence report. We don't have any material changes, additions, or deletions, and we do ask that you adopt the probation's recommendation.
Anything you want to tell me before I impose that?
I apologize about wasting your time.
I'm not wasting my time. I get paid. All right. In case ending in 0597, sentence of the court, $125 statutory fee, $1,750 restitution to JSG payable through the court. I'll order 365 days in jail. Credit the 272 you served. The balance is suspended on that case. I'm presuming that after these cases, she's not going to be released.
Yes, these are the last things holding her.
Ah.
She's on probation in Wayne County.
Got it.
She's been on a writ here, but she's been in custody for quite some time. She was in Wayne County, then Oakland County, then back to Wayne County, then here.
Yeah.
So she's not working, so she's gonna need some time to,
Yeah, the 1750, I'll just make due and payable by December 31st, 2025. And so let her get out, get settled, and try to make sure to try to arrange something regarding that. On the other matter, the case ending in 0111, on count one, the larceny, less than 200, I'll order $125 statutory fee, 93 days in jail, credit 93 served. On the count two, 200 larceny, 200 to 1,000, $50 statutory fee. I'll reserve restitution for a period of 60 days. 300, and I'll order 365 days in jail, credit 272. The balance is suspended.
thank you.
All right, thank you. Court calls the case People versus Michael Kyle.
Assistant Public Defender Natalie Pate for Mr. Kyle, who may be present via Zoom.
Michael Kyle.
Your Honor, I believe this was today set for state review, but I believe it was a show cause. I believe his balance is $360. The numbers I did have for him, unfortunately, are all now disconnected. I did send an email to the last email address I had for him, but other than that, I don't have further explanation for his failure to appear for the record request and adjournments.
Bench warrant will issue bond 5,000, 10% privilege. Warrant will issue immediately. Court does call the case of the People versus Michael Patterson. Did they go back? What happened?
See what's out, Your Honor.
They grabbed home. I would have held whoever.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Patterson. Please state your name for the record, sir.
Michael Lee Patterson.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Patterson, and we do not have any material changes or corrections. I've also had the opportunity to review the recommendation for sentencing with Mr. Patterson. And although we do understand that Mr. Patterson is asking that he be released today and be sentenced to credit for time served, he states that he does reside at the Delana Center, and he is asking if Your Honor would allow him to be released today to go reside back at the Delana Center. Other than that, we would ask the court to adopt probation's recommendation.
Sir, anything you want to say before I impose sentence?
No, Your Honor.
On count one, indecent exposure, $125 statutory fee. Defendant is to submit a DNA sample, a little 365 days in jail, credit 194 days served. Defendant is to serve the balance. On the count 2 indecent exposure, $50 statutory fee, 365 days in jail, credit 194 days served. Defendant is to serve the balance. Thank you.
Sorry.
Great minds thinking alike, Ashley. Yes, we did share the same video. I didn't even see your comment up there. So we made the one video regarding Hoarder Man, which I just put in the pinned chat, and Ashley posted as well. Also, at some point, we had seen him one other time in the live show, somewhere towards the end of August, early September. Maybe it was the 6th of September, something like that. I don't remember exactly. If somebody remembers, let me know and I can find it. But he's in the live somewhere too. So yeah, we've seen him a few times. Let's go to Judge Stevens. Check back in there.
Joshua Simeon?
Yes, sir.
We call 25 CR 206. You are Mr. Simeon with your attorney, Ms. McNally, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about December 7th, 2024 in Jefferson County, Texas, you committed a felony offense. It looks like automobile collision involving injury, and knowing that an accident had occurred, intentionally and knowingly left the scene of an accident without giving your name, address, and other information, and or rendering assistance to another person who was in need of medical treatment because of the accident. Do you understand what you're charged with here?
Yes, sir.
We just had a trial on this a couple of months ago, this exact same case. And whether it's the accident or collision is your fault or not, if you're involved in it, the way the statute reads, you have a duty to stick around and try to help anybody who needs medical attention and not leave.
Yes.
It's a very humane written statute. And people who are involved in an accident, whether it's their fault or not, they have a duty to help another human who may have been injured.
Yes, sir.
It's a very admirable statute. I'm glad they passed that because it's all about decency. In that case, it was a state jail felony, though.
Yes.
And it was enhanced because of prior convictions that the guy had.
I think that was serious bodily injury, and serious bodily injury is a 3rd-degree felony. If it's only bodily injury, the state can either.
He died. The other person.
So if it's death, it's a 2nd-degree felony. If it's serious bodily injury, it's a 3rd. And then there's a separate 3rd category that's unclassified, which is this for bodily injury. And it gives the option of 5 years TDC, a year in county, up to a $5,000 fine, or both. And so we are proceeding on the 1-year county jail. We're proceeding on the misdemeanor.
What's the fine on it?
There's not a fine associated with the plea deal, but there can be a fine up to $5,000, Judge.
Okay.
I ran out of room trying to write it. I apologize.
Okay, so I see everybody agree. The punishment can be imprisonment for not more than 10 years.
No.
Or confinement in the county jail for not more than 1 year, which would be like a Class A misdemeanor.
It's punishment not to exceed 5 years in TDC. It's like a quasi 3rd-degree felony.
But what's written here is or confinement in the county jail for not more than 1 year.
Yeah. So it can be 5 years TDC or county. So there's a felony track and a misdemeanor track.
Which one is applicable for this fact situation?
We are proceeding on the misdemeanor up to 1 year county jail. I just put both in there because I didn't know if both.
And the fine is like Class A misdemeanor fine?
No, it's a fine not to exceed $5,000 on both.
Okay, is that agreeable?
Yes, there's an option.
Do you understand what your options are here?
Yes, sir.
The agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 2 years. And there's another case to be dismissed.
It's a misdemeanor case, Your Honor. It's a
In
misdemeanor.
another court?
Yes.
Is that your understanding of the agreement?
Yes,
If I follow this, you have no right of appeal. Do you understand?
Yes,
How do you plead to this charge? It says felony unclassified, but we're going on a misdemeanor. Is it a lesser included or is it an option?
And it's
under
just
the
an
statute?
option. It's an option with.
Why did the grand jury lawyer write felony unclassified?
Because it can be both a felony and a misdemeanor. It's not, and it's not listed as a state jail either. It's just its own thing. Confusing. Basically just makes our jobs harder, more difficult to judge.
We spent a lot of time on that in that trial, trying to figure it out. And it was enhanced. I think somehow it was enhanced to 10 years. He was looking at 10 years, which is what I think he received.
I believe his was a serious degree felony because there was a death involved. So it changes the classification based on the injury involved. The highest being death, so a second degree felony. Serious bodily injuries, third degree.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it, discuss it with your attorney, or the contents are incorrect?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, giving up your rights to a jury trial, appearance, confrontation, cross-examination of witnesses, totally satisfied with representation provided your lawyer, all true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports away.
Yes, Judge.
Find you are this deeply. You understand and appreciate the consequences of pleading guilty. You are entering your plea voluntarily, knowingly, intelligently. There's enough evidence from State's Exhibit 1 admitted here to support your guilty plea, to find you guilty beyond a reasonable doubt. I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense, including goes to automobile, defense.
Yes,
Some sort of a
I'll add that.
course that where he can get credit
Yes, sir.
for it, and where it will reduce your insurance costs as well. So it's a win-win, and makes you keep in mind that you have obligations. And I think a lot of people don't understand this. They think, well, it wasn't my fault. I'm driving off, and you can't do that. It's a very humanitarian written statute. So. What happened on that other case, that poor person was just left to die, and others didn't really know how to help. All right, please see the probation officer and do well. Okay.
Thank you, sir.
Thank you, sir. And then we have. Yeah. Rick,
I don't know. I'm not sure.
Richard Cook.
That's not me, Judge.
Richard Cook. We're going to call Richard Cook again one more time on 22-39655. Richard Cook, no answer in the courtroom. I'm asking the bailiff to call into the hall for Richard Cook. And again, there was a bond forfeiture
I believe he's had several.
We're gonna double slap on the bond forfeiture. No response to the name called in the courtroom, no response to that name called into the hall. The defendant has failed to appear. But what does it show? Was he informed of this event that we know about?
He has the bondsman, so I would assume it's possible.
Well, I feel like I can't. He's already had his bond revoked, so
No, he hasn't had his bond revoked.
Oh, it was. I thought
That was somebody else, Judge.
this says bond forfeiture, $15,000 GPS. Here, see that?
Oh, okay. I thought you were talking about the current bond.
Yeah,
He's on a $15,000 bond.
So, but he posted another bond? Oh, okay. What is this bond that's currently
It's
pending?
15,000.
All right, that is revoked. Another warrant will be issued for his arrest, and that's double to $30,000 plus home confinement and GPS device. Oh, okay. Reagan, what else?
Judge, we had help Ronnie Palmore.
Yeah,
to
come on up, Mr. Palmore.
Mr. Boyd is working on that currently. We're trying to get some answers in regards to those
The priors.
and then the potential punishment range.
Can you tell the jury we're just going to need a few more minutes and thank them for their patience? Thank you, Dennis.
Your Honor, it looks like it's gonna be I want to make sure the content together.
Here was this.
We're going to preempt this. I've got no idea what's going on, but I just glanced up and Simpson was screaming at a lawyer. So I put us in the Wayback Machine just a couple of minutes, try to catch this at the beginning. Let's see what just transpired here.
I also have a motion to withdraw, which seems rather weird to me. So wherever you'd like to start.
Your Honor, just in terms of the motion with withdraw, I did submit that request in advance, hoping that we would have the opportunity to be heard on that prior to today's hearing, not to cause any prejudice to my client. I am here, Your Honor, for today. I think it's the most efficient use of my time that I'm going to stay on with Ms. Wilson for purpose of the restitution hearing, since I'm already here.
Well, just so that we're very clear, and the reason the court did not sign the order is because the restitution hearing, particularly at your request, is part of sentencing. And I would not permit counsel to withdraw in the midst of sentencing. It just would not happen. So it's good that I don't have to deny the motion, but I wasn't signing it. But all right. So it's withdrawn. What are we doing with regard to the restitution? In my understanding, the victim is here via Zoom.
She is here, Your Honor. I wasn't sure. Thank you, Your Honor.
Well, that's what I think I was informed of that. Ma'am, are you here?
Oh, yes, I am.
Yeah, okay, there you are. Okay. Thank you very much. All right, what are we doing?
Your Honor, has the court also received the estimate that was provided by Michelle Miller reference from Great Lakes Collision Frame for the repairs?
The one that is 3,229.08.
That is correct, Your Honor.
Yeah, I do that.
So, Your Honor, we could proceed to the hearing. I'm not sure if defense counsel, now that Ms. Miller is here, is willing to stipulate to the rest of the matter, if we do need to have a hearing.
We're here for the hearing, Your Honor.
Your Honor, will the court allow Ms. Miller to testify via Zoom?
That is how she's appearing. So yes, I
Ms.
will.
Miller, are you able to testify right now, or are you busy with something else?
I'm working.
Okay. Is there a point, Ms. Miller, that you're going to have a break or a point where you can answer?
In about an hour and a half. In about an hour and a half. In about an hour and a half, I'll be done with this head and I'll have this client under the dryer.
Got it. And then you'll be able to take some time and testify?
Yes, sir.
Okay. Then what I'm going to do, said about an hour and a half. What is it? All right, because her testimony is needed.
Can we have just a moment to confer with defense counsel to see if that's gonna work?
Yeah, Your Honor, I didn't block off a whole day for.
Well, counsel, you're in this case, whether you blocked off a whole day or not, is irrelevant to me.
I'm in this case because you wouldn't sign the consent order for me.
Because it's inappropriate. It is inappropriate to ask to withdraw in the midst of sentencing.
It's not.
And you have no authority. Do not interrupt me. You have no authority to show that that is appropriate.
Well,
it will be denied. Don't do that, counsel, because you don't want to go there with me. Not today.
Judge, I am being respectful as possible.
Huh. So that got so heated that Judge cut the feed. That's a shame that he cut it. Because that would have been something to see. I had no idea that feed was going to be cut. Like I said, I just kind of wanted to go there to see what was going on because I just glanced up and he was screaming at the guy. I don't know. Really wish I would have known how that ended. But maybe he didn't want the guy being held in contempt to be on camera. Anywho, Judge Glazer for a few minutes.
Is he eligible for program or no? There's priors. There's no priors. You want to post a bond or you want pretrial? Wait, pretrial.
He wants to post a bond.
All right. Count one is the armed possession of cocaine is $2,500. Count two, armed possession with intent to sell cannabis will be $1,500. And count three, possession of cannabis over 20 grams. Be $500. Have a good day. Next is Casey Estrada. I'm sorry, you want me to call Edward Murray?
The court is ready. I am
Ready. Edward Murray.
Judge, you had asked, or I had asked for the opportunity to show the judgment and sentence. Here's F2421648, adjudicated guilty of a grand theft.
Okay.
I'm scrolling down, signed by Judge Laura Cruz on November 20th, 2024.
Okay. There's probable cause on F25-20763 for petty theft with a prior conviction. He refused court. Public defender's office is appointed with presence. The bond will be $1,500. F25-20763. F25-20743 is retail theft, multiple items or locations within 30 days. Let's see. There's probable cause here for retail theft. The $7,500 bond in F25-20743. And then F25 to the last, I'm sorry, 7,500 for the retail theft for 30 days. Within 30 days, multiple thefts within 30 days. F25-20765, there's probable cause for petty theft with a prior conviction. That bond will be $1,000. Now we have Casey Estrada. Page 15. Good morning, sir. You were arrested for aggravated assault with a firearm and battery. In the second case, fleeing and eluding a police officer, resisting an officer without violence. I will appoint the public defender's office for you, review for probable cause.
You have 2 cases, Your Honor?
Yes, 2 cases. It says, sir, you are ordered to stay away from Ramses Campos, the alleged victim. No contact with the victim, alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And you may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order, sir? All right. $5,000 bond, count 1, 1,000 count 2 for F25 20840. Then the other case, the fleeing and eluding, I need a review. There's probable cause for fleeing and eluding a police officer. It's a $2,500 bond. And there's also probable cause for resisting without $500. Have a nice day.
Judge, on the case ending in 20840, would Your Honor consider a reduction in the bond? It's from September 2023. He's not living with the alleged victim, Judge.
Okay, I'll do that. I'll set it at
Am I going home today?
okay, I'll do 2,500 count 1 and 500 count 2. And then the other case, the fleeing, is a 2,500 and 500. Roy Griffith, page 16.
Okay, guys, we're going to head back up to Judge McNally for a few minutes. A whole bunch of courts just suddenly ended, so I got to figure out more to put in the queue for us. But I had a personal favor to ask. We are currently at 24,932 subscribers. That puts us 68 away from the 25,000 mark, which is obviously a big milestone. I'd really like to hit that by Friday if we could. So if you like what you see here, please share this far and wide. Tell your family, tell your friends, post it on your social media accounts. Help me please get to 25,000 by the weekend. I'd really, really appreciate that. And thank you in advance. So let's go to Judge McNally.
665. Your name, sir?
Wesley H. Pfeiffer.
Mr. Barbie, good morning. Your name?
Good morning, Your Honor. Greg Barbie, appearing on behalf of Wes Pfeiffer. I apologize for the mix-up, Your Honor. I thought we were doing this via Zoom, but I did not inform my client, so I will take the blame on that.
That's fine. You either both have to be here or you both have to be in your office together in the future, okay?
Understood.
All right, so what are we doing? We're just going to adjourn this a week or two because these civil infractions have been ongoing. I got to get rid of these cases. I don't mind the misdemeanor lingering, but what are we doing here?
Yes, Your Honor, it's my understanding that my client was going to plead not guilty to the misdemeanor, and that was going to get a new date, and then the ordinance violation was going to be held over so I could continue to speak with the prosecutor.
All right, so first of all, so he stands mute and waives formal reading on the trespass case, correct?
Correct.
So I'll give you a personal bond on that, sir. $500. You don't have to post any money, but here are your bond conditions. You're not to have any contact at all. No contact at all with Michael Uchuk. No contact with him. You're not to enter the property address at 23463 River Road. Is that just River Road?
West River.
Yeah, they didn't put that in here. Okay. West, I didn't think they had a River Road. West River Road in Grosseal. What are these, so we'll give you a copy of that bond sheet. Also, you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes, sir.
All right, now I need to move these other two on, so I'm going to set these over in 2 weeks, and we're going to have to do a these are different offense dates. So this trespass was from July 25th, and the other citations were from August the 20th. So I'm going to set these for a formal hearing in 2 weeks. So everybody's going to have to be here on October the 7th. What time are we going to do this, Lisa?
October 8th at 8:45.
My mistake, October 8th. You said at 8:45?
Yes.
So that's what we'll do. Formal hearing, October 8th at 8:45. We'll have to go to hearing if it's not resolved by then, okay, Mr. Barbie?
Sounds good. Thank you, Your Honor.
And then the other two I will put over till October. I guess we put the trespass over to October 8th for the next pretrial. And if that doesn't resolve, then we'll set a final pretrial and a trial date on that trespass, okay?
Okay,
So,
thank you.
understand everything, Mr. Pfeiffer?
Yes, I do.
All right, so you can go down the hall and get your notice, and we'll see you back here in a couple of weeks. Thank you.
Very good, sir.
Thank you.
Thank you.
Joshua Edward Schaefer, 25B149-261 A and B. Name?
Joshua Schaefer.
All right, so we'll adjourn this a couple more weeks, okay? October 8th, Lisa,
Excuse me, 10:15. 10:15.
okay, it's at 15, all right? So you can go down the hall and get your notice, and if it doesn't resolve next time, we'll just set it for trial, okay? Good luck. Aaron James Harper. 25W 839-353, 25W838-175, 25W838-256, 24B146-691B, and the misdemeanor, 25B148510. Your name, sir?
House Counsel Attorney Mike Boland for Mr. Harper on all files, Your Honor.
You were supposed to go over to probation.
Yeah, I read the register of actions. I'm not, it looks like twice.
Listen to me. Hang on.
Yes.
You and I are going to get along. Okay? I told you to go to probation July 3rd. And you didn't appear. They sent you a listing. They sent you another date, I should say. And then you failed to appear on August 13th for sentence. And then a bench warrant was issued. And then we canceled the bench warrant on September 9th. And we set your sentencing for today. And you still haven't appeared.
Called
Called who?
here basically almost every day.
Who?
Up front.
What number? What number did you call?
Almost every day.
What number did you call?
The number for the 30.
Well, tell me what it is. Yeah, I want you to grab your phone. I want you to show me all the times you called the court. Called here almost every day. Did we answer? Did we return your calls?
That's what I was gonna say. So, they told me to come the other time. That was just, I came in front of you. It was for the, I guess I had to, it was like a pre-sentencing thing. And then I called and they told me to come back today. Like they told me to come like last week for the other ticket misdemeanors.
How old are you?
24.
Do you work? Wait. Do you work?
Yeah,
Where?
at Ford Motor Company.
You've got a job at Ford Motor?
Yeah.
How much you make there?
Probably about 800 every
How much per hour?
like 17.
Listen. Quit acting like an irresponsible child, will you please? I'm dead serious.
I am too. I've been calling that. I've been getting my dates and everything.
If they told him to come in to do the PSI interview this morning, that would be easy to check.
Yeah.
And then I don't see.
I mean, you can read this.
I read the.
They're sending him notices and he's not responding. What are you calling for? Just respond. You were supposed to be there for your PSI on August the 6th at 8:30. You didn't appear on as of August the 8th. No phone number listed. Redford address only. Then you failed to appear for your sentence August 13th. For some reason, we canceled the warrant that day.
It might have been because I actually came in for it. I came in. I spoke with the other attorney.
All right, so then we canceled the warrant.
Every time they told me to come, I basically came, and I just had to come. For this matter, besides the tickets, it was the other time where I talked to the lady attorney, and then it was today. It's the only time I called and told me to come, unless it was on the notice, and I didn't see anything.
Here's what we're doing. I hope you don't have anywhere to go.
No, that's literally it. It's just those.
Listen.
We can have it done today.
Thank you. I was going to say,
I'm a mind reader, Judge.
you're going to wait until they can accommodate you. We're going to give you a notice. And you're coming back. You got all kinds of contempt citations. You better be saving your money. If I were you, I'd probably get another 40-hour-a-week job because you got all kinds of money you owe this court. And you got a restitution amount on this defrauding an innkeeper in the amount of $702.79. And let me just tell you how much these others are: 213, 225, 77, and let's see on the expired plate. That might just, I don't know how. Listen.
Does he have a bond that he can apply at the time that we address this matter? I thought I saw a $1,700 10% bond
Where was that at?
in the Register of Actions.
No, I wrote down 7,500, 10%. He never posted a nickel. Better to wait for PSI today.
Yes, Judge.
If that means you have to sit in that lobby all afternoon and morning until 4 o'clock, that's what it means. If you want to be a child, I'm going to treat you like one. Sentencing date will be
October 8th at 8:30.
October 8th at 8:30.
I'm sorry.
October the 8th at 8:30.
Yes.
Time to grow up, Mr. Harper. I mean, honestly, I'm looking at these citations. I don't know who you think you are. You just don't take care of anything.
They're done now. He's brought in his paperwork. I have not looked at it, but my understanding is he's taking care of the expired plates. Is that correct?
Yeah, no, but he hasn't,
He hasn't taken care of the contempt on the ticket.
he's got a bunch of tickets here. 4 of them.
Yes. Yes.
You got a good job. You're gonna give it to somebody else if you're not careful.
Yes.
Go down the hall, get your notice, go over to probation, sit there and wait. Do not leave this property. If you do, I'm telling you, you are going to go to jail. Do we understand one another?
Yeah.
Good.
I think that's
Siklawi, Maher Siklawi, 25B 149 407 A and B. All right, your name, sir?
fine.
All right, so you have a valid license. They're going to therefore dismiss that, they're saying, and they want you to plead to expired plate. Is that what you want to do?
Yes.
To the charge expired plate, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the driveway license not valid pursuant to stipulation. Motion to the prosecutor, 135 is your fines. You can go right down the hall and take care of that. Have a good day. Thank you. People against, James Curtis Yadon Jr., 25I415116, A and B. Morning, Mr. Nykel.
Good morning, Judge McNally.
So I have your appearance, please.
Edward Nykel, on behalf
Okay.
of James Curtis Yaden Jr., who's with me.
Sir, your name, please.
James Yaden.
So I've got a stipulated plea agreement. It says this is going to be a guilty plea to the charge of operating while intoxicated. Wait a minute. Think he's a newer prosecutor. My understanding is I think he put in the wrong case number here. So he's going to plead to the operating while intoxicated, which should be 116A. He's got 116B written down. And then the super drunk, which is 116B, was to be dismissed. Is that what you two would agree to?
Not sure how the court processed it, but yes, because the citation that was issued had 2 counts. One, A was operating while intoxicated, and B, it didn't say B, but was operating with BAC of 0.17.
Yeah, so he just put the wrong case numbers down. So I just want to confirm. The intent was he plead on the A file, which is the operating while intoxicated, with the B to be dismissed, the super drunk, right?
That is correct. And that was confusing because Mr. Yaden was actually issued 2 separate appearance tickets. The first one was just for operating with BAC of 0.17 or more. And then the next day he was served with a second ticket number. They may not have filed the first one. It was 1415115 was the ticket number.
Okay,
This one that was issued was 1415116. So
okay.
Yes.
All right, so Mr. Yaden, do you understand what your lawyers worked out here? They're going to dismiss the 6-month super drunk charge. If you plead to operating while intoxicated, which is punishable by up to 500 fines, 93 days jail, 360 hours community service. Court costs are all those 6 points, license suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record, sir. Do you understand that?
Yes, sir.
And you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You enjoy the presumption of innocence. If you plead guilty, you're giving up your right to a trial of any kind. You're giving up your right to a jury trial, and at that trial to testify or remain silent, to cross-examine their witnesses, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and you're waiving the requirement that they prove you guilty beyond a reasonable doubt, as well as your presumption of innocence. Do you understand that?
Yes, sir.
All right. Do you have any questions before I ask you how you plead?
No, sir.
To the charge operating while intoxicated, how do you plead?
Guilty.
Were you operating a motor vehicle on Groseal Parkway near Meridian in Groseal, August 17 of 25 at 8:03 in the morning?
No. It actually happened in the afternoon, Your Honor.
In the evening.
The prosecutor, Groziel?
Sir.
Oh, I have the
Counselor.
first citation, Your Honor. That was the 115. Indicated that it was on August 16th at 9:02 p.m.
Your name? Good morning again. So there seems to be a discrepancy as to when this incident occurred. The citation indicates 8:03 a.m. Who wrote this citation? Officer Benson.
Sir, do you have the hearing meeting? Is that citation?
I have the 15116 A and B. You wrote it down wrong. No, not. You wrote down that he's going to plead guilty on the B file, which was super drunk, but you wrote OWI next to it. So I understood that he was going to plead operating while intoxicated on the A file with the super drunk, which is set forth in the B file to be dismissed. That was the intent, right?
For the OWI, yes, and I believe I got that information, I thought I pulled it from the court's website, so I made a mistake, but it is the township's, the offer was to plead guilty to OWI and dismiss IBAC, Your Honor.
Right. But now we've got a discrepancy on the time. So you're telling me that this did not happen on August 17th at 8:03 in the morning, right, Mr. Yadon?
Yes, sir.
Did it still happen on August the 17th?
In the evening, yes.
Okay.
Judge, I pulled the original ticket. It's the 16th at 9:02.
What are they doing on it?
I think they reissued the ticket the next day and then used that day's date.
They gotta be careful though. I know these computers do a lot of work, but they're telling me it happened on a different day.
I believe that the issue, you're exactly right, Your Honor, there was a citation issued initially, and then there was one issued the following day to reflect the IBAC.
I know, but they've got it on so they're alleging that the offense occurred on August 17th at 8:03 in the morning, when apparently it was on August the 16th in the afternoon. Why don't you do me a favor?
Yes.
Do you have a police report out there?
Yes, sir.
Go get the police report, and then you can move to amend the citation to the offense date of August the 16th at whatever time it reflects on the ticket. And we can make that change this way, okay?
Yes, sir.
So I'm gonna pass this right now, Mr. Nichol, until he does that, okay?
Very good, yes.
We'll be right back with you. Thank you.
Yes.
All right, Wygonic?
All right, let's switch things up a little bit. I'm going to stay in the Detroit area, but we're going to go to Judge DeSanto, Judge Mom. It's been a few weeks since we've seen her last, but it appears she's had an audio upgrade. You can actually kind of hear her now, so let's give a listen.
Improvements. Not improvements, but repairs. There are emails in prosecutor's file that she has forwarded to me from the building department, giving all the distance that they've given to Mr. Layton and his activities. Because of that, Your Honor, the people are also moving to dismiss the other initial files of 241677, 2594, and 25207. I've explained to Mr. Layton circumstances. He understands those and is quite thankful to the court for its lenience. Well, leniency being one thing, but he has now gotten everything together as he's supposed to.
Okay, 90 days?
Well, he's got the people, he hopes to have it done before then. But he does have the permits, and I believe that there were some conversations about how long this may take, and I don't believe that the building department has any objection to that. Hopefully it'll be done before.
Okay, so, Mr. Layton, your name for the record, please.
Lance Michael Layton.
Okay. And so you already have a contractor. It is the porch, right? Is it the porch?
The porch.
Okay, and you already have a contractor?
Porch and landing. Well, I've got a friend that's gonna help me out, yeah.
Okay, the permits have been pulled. Right.
And paid for it.
Okay. And so your friend, how long has he indicated it's going to take?
I'm meeting him this week. Pro excavation out of Wyandotte, they're gonna help me out.
I'm sorry?
Pro excavation out of Wyandotte, they're gonna help me out, yeah.
Okay. So did he give you an indication as to how long it was going to take?
I just picked a paid permit up Friday afternoon, so we're gonna go over it, and he's gonna see what needs to be, the exact, what's entitled, or what's gonna be need to be done, as far as the measurements and what's all involved.
Okay. So, all right, so I'm dismissing all except for the 251128 A and B.
That's correct, Sharon.
And so 90 days puts us around the end of the year.
That's correct, Sharon.
And obviously, if it's not done before then it's not getting done until later, because obviously you can't, is it a brick porch?
It's a front porch, Sharon.
Right, is it brick?
No,
Block?
there was brick going up, but they had me tear it out, and I was just gonna replace the entrance, but now the new ordinance, I gotta put a landing down, excuse me, and so it's a lot.
That's okay, Ally has another ear, I think. Right, so that's my question, is it going to be
It's gonna be made out of wood.
wood? Okay. But you have to still set the posts in with the concrete into the ground.
Concrete and a cement slab landing
Right,
for where the steps come down.
right, so you're kind of running up, there's no talking in court.
You guys need to talk.
So you're kind of running up against some weather, and some seasonal constraints. That's why I'm asking. So I think 90 days might be a little bit too far. So let's do it for 60 days. And then, I would presume within 60 days, you would be done, correct?
Yes.
Because if we're going after that, then I don't think there's gonna be any,
Well, we can get the underground work, you know, the post set and the cement on, it's just the upper, what's the frost.
So at least if he has that in the 60 days. The post,
well, the hope is that it's going to all be done in 60 days, right?
I agree.
So, okay, so. Let's set this for November 26th. Okay. Well, okay, hold on. I say November 26th. That's going to be a very full day. It's our Wyandotte docket, our city of Wyandotte docket, and our combined state docket with us on the 28th because we have the because we're closed for things after. So do you want to come that day, or do you want to do the,
First,
let's do December 3rd.
December 3rd.
Okay. At 9 a.m.?
Thank you. Ann.
Okay. All right.
Thank you very
Very
much.
good. Thank you.
Thank you, Your Honor.
You are welcome. I'm glad that everybody has been able to communicate with each other and have a full understanding as to what's needed. All right. And then we are on the record. Nope. Do we have any more of Mr. Goldboss season here?
Sorry, what are you doing?
Oh, I was just talking to Terry. Did you find Cross Class?
I didn't see anyone.
Okay, well. Bobby, can you grab Neil for me, please? I didn't see any because I saw Mr. Serrano's in there, but,
No.
okay. So, Marcy had the file, it was on my desk, and she added an appearance in there, I thought.
Marcy had it.
Yeah, well, yeah, it was at my desk, but,
I saw it.
I know, but then I think it got moved towards the other, like by the chairs. It wasn't there at all? It's not anywhere on on my desk, huh?
I'll look again.
Okay, well, I didn't grab that file here.
What's the name again?
Gross Class.
Yes,
Okay, interesting.
that was the one that we were not
Right, and then she added an appearance in there.
correct. I will look again, but
Okay. Thank you.
Turn your phone off and report.
I had already
If
checked.
you want to scroll around or do whatever, go out in the lobby, please.
Okay.
All right. I'm working on something here for you guys, but while I'm doing that and while she's between contestants, let's go to let's go to Louisiana. I believe they're doing revocations. Let's see what's going on.
DOC headquarters. Today, our remote location is at Iberville Parish Jail. Would the staff at the facility please introduce yourself for the record? Is there anyone in there with you, sir?
Yes, ma'am. I'm Deputy Brooklyn Landry.
Okay. Okay, and then, Mr. Green, will you introduce yourself with your name and your DOC number, please, for the record?
I have Albert Green and Dawu Seals. For which one are you wanting to do first, ma'am?
Oh, I'm sorry. Okay, Albert Green Jr.
Okay, let's do a swap. All right.
Okay.
All right. My name is Albert Green Jr. DOC 285637.
Okay. All right, Mr. Green, I'm going to read from the master record some information and then you let me know if it's correct, okay?
All right.
All right, you are a second class offender.
Okay.
Parole eligibility date is 12/14/2022. You have an adjusted good time date of 8/16/2038. Your full-time date is 4/5/2058. Your sentence is a total of 60 years. And you were charged with first-degree feticide and then firearms with a convicted felon and then a manslaughter charge. Is that correct?
Yes, ma'am.
Okay. Hang on just a second. Mr. Green, will you please tell me the reason you are incarcerated and why you should be released early?
The reason I'm incarcerated, I went to a trailer and fired some shot in the trailer and shot someone.
Okay, so you just fired some random shots into a trailer and somebody got killed?
Yes, ma'am.
What caused you to fire shots into a trailer?
Well, I went there by domestic dispute.
Okay. Well, you're going to be questioned more later. Okay, now, secondly, why should we release you early?
Why should you?
Yeah.
That's a hard question. I would say because of my conduct, but really, for the type of charge, there's no justification to it. So, I mean, I wouldn't be the one to answer that.
So did you request this parole hearing, sir?
Yes.
Okay.
It had been requested for some time.
Oh, okay. All right, so ward, is the ward present or the person in the room? Do you have anything you'd like to say on behalf of Mr. Green or his conduct at the jail?
He doesn't give us any issues here at all, ma'am. He's a very respectful inmate here at the Iberville Parish Jail.
Okay. And that's all you know about him?
Yes, ma'am.
Okay. All right. So in support, you don't have anyone here today. In opposition, though, we have at headquarters, I'm gonna read all the names and then some are gonna speak. Henderson Holmes Sr. He's gonna speak later. Henderson Holmes Jr. is gonna speak. Tiara Holmes, she's at headquarters. She's not gonna speak. Tina Holmes will speak later. And Maria Holmes is at headquarters and she is not gonna speak. So at this time, Henderson Holmes Sr., would you please go to the podium and address the panel, please? Yes, sir, that right there.
Yes,
Okay.
I think you should remain in prison because on that day he committed this crime, he not only killed one person, he killed several people. Me, myself, my family. He hurt all of us that day, very bad. This is one life, and this is very bad. I hope that he never gets out. Does not steal anywhere in it. And he's very deceitful. He doesn't always tell the truth. That's not been knowing. He'll do anything to get his way. He'll even lie. He's not a good person. It's hard for me to go. Take your time. Just looking at it. Takes us way back to the day we long, which never happened. When he went into the house, he didn't just go there to visit. He went there with his mind made up. He was gonna kill somebody that day. And he did. He shot through a bedroom door. Where Cynthia had a backup against the door, keeping him from getting in that room. He shot through that door several times. So he tried to break into the front. Instead, he got into the house through the back. And this is the way you do friends. You don't do people. You don't go to their house. I can't say anymore.
Okay, Mr. Thank you for speaking today. I know it was hard. It's difficult. Okay, now we have Henderson Holmes Jr.
The same. He deserved to stay in prison. He killed one of our family members. Also tried to murder my other sister. That wasn't the first time. Like my dad said, you don't do. Excuse me.
She can stand up there with you for support if you need it.
You know, you don't treat people you care about the way he did. He should have been charged with murder when he beat her with a bat. They never charged him for that. And right after that, you go and try to murder her and then kill one of our other relatives. But you don't know why, you know, there's no explanation. We have to live with this for the rest of our lives. And when we go to our officials to get answers, we can't never get none. We will rush through a process that seems to help him out. You know, we never got support from this, and it's hard to move on. I don't care how long it's been, we'll never get through it. There's a lot more I wanted to say, but I'll say he got his time. He deserves to spend the rest of his life in jail doing his time. And I had more to say, but I can't get it all right.
That's understandable, Mr. Holmes. Thank you. Okay, and now Tina Holmes.
Yes, ma'am. I is Tina Holmes. This is not my first time on it. This is actually my second time. What he did that day, he did not have to do it. He did it because he wanted to. Just because I was the first victim for Washington. I was the victim that got killed, but I was the girlfriend victim. So he actually came there for me. He shot through the front door once because he couldn't pop it open like he wanted to. So he tried to go to the back. I went in one room, she went in another one, but he didn't know who was where, and like my dad say, she was up against the door, and I guess when he realized he couldn't get in, he just shot through the door. She was the one actually pregnant. I don't even know if she got to even know what her baby was gonna be, a boy or a girl. We didn't even get to have that happen on. She had 2 kids already. She would never be here to get to see them graduate, have kids, get married, or anything. So why should he be able to get out and live the rest of his life for something he chose to do that he did not have to? I done lived with this all since, you know, feeling like it's my fault when I know it was not, because he did not have to. He chose to. No matter what he didn't accomplish up in there, anger management classes, whatever, that is irrelevant to me. What if he might lie and sit here and tell y'all he did his life over, he didn't change. I'm still a resident of Iceville Parish that he may come back to. What if he try to finish his job? Or I have to make do him. And that is something I don't want to have to live with. I got enough on my plate to have to keep reliving this. Right. He needs to stay where he at. And whatever happened to him, I don't care. She have 2 kids that's still out here. They were very young. They never even got to know what their mother's love would have been like. That baby never even got born to even have a future to know what that baby would have been like. Yeah. So why should he come out and be with his family children? You see, ain't nobody even here for him. He chose to do it. Let him live where he at. For the rest, tell whatever happened to him. And that's all I have to say.
Well, Ms. Holmes, thank you for coming. I do know that it's very difficult.
Yeah, and I had to suck my tears up to say what I had to say just now.
I know. Thank you so much.
But thank y'all.
Yes, ma'am. Okay, your case has been assigned to Mr. Steve Prater, Mr. Prater. He's going to begin his interview right now.
Thank you.
Hello, Mr. Green.
All right, good morning.
You kind of write this off as just a domestic situation where you shot into a trailer. It's a little more than that, wasn't it?
Well, I didn't shoot into the door. I stuck my hand into the door and shot on the floor first.
Right. I read the police reports, and you tried to get in with a pinch bar, crowbar.
I broke the window out.
Yes, sir. Broke the window out, held the gun through there, and shot through the window that you broke out. Then you ran around to the back and shot 2 or 3 times into the door, right?
No, not into the door. The door was open.
Okay, so you shot into the
into the trailer, right? The door was open.
But you saw the victim there, right?
Yes.
Okay. All right, and you killed this lady and you killed her baby, correct?
Correct.
Okay. Tell me one other thing is in right before this shooting, a few months before, you were charged with an aggravated battery, correct?
Yes.
Who was that against?
That was against Tina.
Okay. All right. You served about 40% of your time that you were given for killing 2 people and for having a firearm that you knew you weren't supposed to have because you were a second offender already. That sound correct?
Yes, it is.
Okay. That's all I need.
Thank you, Mr. Prater. Ms. Ledoux, do you have any questions?
No, ma'am, I don't have any questions.
Okay. I don't have any questions either. All right, so Mr. Green, do you want to wrap it up? Do you have some statements you would like to make on your behalf?
No, that's good.
You have nothing to say?
All right.
Okay, is the board ready to vote?
Yes, ma'am.
Okay, Mr. Prater.
My vote is to deny this request for early parole because of the length of time that he has not served compared to his sentence, and because of the apparent lack of remorse in his parole board hearing interview.
Right, Ms. Ledoux.
Mr. Green, I will commend you on your conduct, your educational pursuit, and a well-written letter that I read. However, at this time, my vote is to deny your parole. You have a little ways to go before I believe you're ready to re-enter.
Okay.
Mr. Green, it's my turn to vote. I agree with my colleagues, and I also add the heinous, deliberate nature of the crime, and that this is an ongoing grief that this family has to suffer for the rest of their life. And this is very difficult for people to have to come to parole hearings.
Yes,
So, yes, sir, and seem to understand that. Okay, so at this time, your parole has been denied, and the time is 10 o'clock. We sign? Okay.
Denied. To the surprise of no one, I suppose. So we're going to go back to Judge DeSanto to finish out the show, I think. But before we go there, a big thanks to Julia. She's been doing a little bit of sleuthing behind the scenes. And I present you now with a Google Earth photo of the hoarder's property. So you can see it on screen. For those of you on the podcast side, I'll try to describe what we're looking at. So toward the top of the screen there, that is the property next door. So ignore that, those two buildings. But the house with the vehicles next to it towards the lower half of the image is what we're talking about here. Oh, you can't see it. Now you can. Thank you, Lindsay. I forgot to hit a button. So anybody on their bingo card, Dan forgot to hit a button or Dan hit the wrong button, there you go. Anyways, you are now seeing on your screen hoarder property. Thank you to Julia for her sleuthing, and thank you to me for screwing it up. But again, so at the top, those two buildings there, that's the house, that's the property next door, so ignore that. We're looking at towards the bottom half of the image. So that's the guy's house. In hearings, it was referenced the boat, and it was referenced like the motorhome, camper, recreational vehicle, whatever. You can see those two sitting there. He does have one car out front. There appears to be a decent amount of junk between that that like camper or whatever and the house. It looks like there's some stuff perhaps around the tree line back behind the home. There's definitely a lot going on. So here's the interesting thing, though. This image was from 2020. And going back through Google Earth, every year there's a different picture. Some of it's blurry, some of it's visible. But the bottom line is, going back as far as 2016, we can see that this property has not changed. That stuff has been sitting there for at least a decade. So for the township's frustration with the guy, for the court's frustration with the guy, I can totally get it. Like, nothing's moved. If you go and you look from year to year to year, I only have the one image loaded because Google Earth and OBS don't play well together, so I had to do a screenshot. So we're just looking at 2020 right now. But if you go and you look from year to year, nothing changes. Nothing's been moved. If anything, things get added. So I can get where everybody's frustrations lie with this guy. Yeah, undoubtedly it's Lady Jack says, oh, I'm sure it's way much worse. Yeah, it probably is by now. But that's where it stood 5 years ago. And I will tell you that 4 years before that didn't look a whole lot different. And heaven only knows what it looks like today. The more recent images are pretty blurry. It's kind of hard to see what's going on, but that's where that's at. So if you're curious about Hoarder Home, and heaven only knows what it looks like inside, because they had complaints about the garage and stuff in it and broken windows and everything else. This is just what we can see from a satellite image, but it's telling, especially the fact that it hasn't changed for a decade. All right, let's go back to Judge DeSanto. We'll finish out most likely right here.
All right, thank you. And good morning. Today is the date scheduled in this matter for the pretrial. And counsel?
Yes, my client is accepting responsibility for the offense as charged, this possession of paragraph.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right. And you heard the plea that was placed on the record, correct?
Yes.
As to the charge of possession of drug paraphernalia, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
I have.
And you understand all of those rights?
I do.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yeah.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yeah.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? Any immigration issues?
No.
Counsel, if you can please order your client.
Yes, so Mr. Lawful, do you recall being in the city of Wyandotte on about the 13th September this year?
I do.
And at the time you had an interaction with a Wyandotte police officer, is that correct?
I did.
During that interaction, the officer determined that in your car, there was a glass pipe which is typically used for the consumption of crack.
There was in the vehicle.
Brown said.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge, dismiss, and are you asking for a sentencing?
Yes, ma'am.
And counsel, what would you like the court to know?
Like the court knows that my client is prepared to take a drug test. He just doesn't.
I don't smoke crack.
Smoke crack.
A lot of people use that vehicle. It's a family vehicle. No, I don't smoke crack, and I'll take a drug test to prove it.
Mr. Malcolm at the same time is not claiming to be an angel. He has some residence with the law in the past. He's not currently on probation or parole. He's got one of the hardest jobs that I'm aware of. He's a brick mason and been doing that for 5 or 6 years. He's currently on suspension because of discharge until he gets this charge resolved. Again, at this point, I think that the fines and costs would be appropriate and then within the interest of justice.
Okay. So, sir, what about nitrous oxide? Would that be detected in your system?
Not at the moment, no, but I went through the night to have a look. It was normal.
Right,
I
and
was not-
with the mouthpieces and
I was
not,
under the impression, they were illegal. Now that I know that they're illegal, I won't be touching them anymore. I bought it legally in the stores in a box. And
okay, hold on.
I apologize about that.
So let me just say this, sir. There may be items that are legal for purchase, but when you use those in a fashion for which they're not intended, then it becomes illegal. So, puffing something that's legally purchased for, I don't know, computer screen cleaning or keyboard cleaning, whatever, right? When you use that for its unintended purpose, and then you're inhaling those chemicals and it's altering your brain, sir, that's illegal. That's illegal. Not only that, it's extremely dangerous.
Yeah, I was getting some pretty effects from it too, so I won't be doing that anymore.
Right. Did anybody check with, are you looking for that one? Did anybody check with Marcy?
I'll go check.
Okay. All right. The court's going to order a $300 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $625. Are you able to pay that today?
I think there's a bond that might be applied.
There was a $350 bond, 10% was retained per statute, and it was paid by Georgie Domsick.
Yes.
So if that person wants to sign over the bond.
I got
to
my
be-
paperwork this session.
Okay, hold on, sir. Only one of us it can only record one of us at a time. Okay, I understand you're excited and want to get me the information, but let me just finish first, okay? So if that individual is here and would like to sign over the bond, that person can do so. They just have to make sure they have their identification. Okay, they have to stop at the window to do that. And then there's still, so then that 10% retention leaves the balance at $315 bond balance. So then there's still $625 that's owed. So do you have an additional $310 to pay today?
Not today, but I can have it by Friday. If you can give me till Friday to pay it, I'll have it.
Okay. So, this Friday, the 26th?
Yes, ma'am.
Okay,
I could probably have it later today. honestly.
that's fine. And if, with that,
Don't push.
that's fine. I'll give you until Friday, sir. Any other questions?
Nope. Nope.
Okay. All right, thank you. Have a good day.
Thank you.
You're welcome.
Okay, friends, a couple of minutes early, but it probably makes sense to end things there since that was the end of a hearing. I hope you all had fun today. We got to see Hoarder Man and see his house and see a couple of other fun things. And I've said it before and I'll say it again. There is no other place I'd rather spend mornings than right here with you guys. It's a lot of fun. And apparently it is for you guys too, because you keep tuning in, and I really appreciate that. So let's do it again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Plus we have Sidebar tonight with the triumphant return of Ashley at 8 p.m. Eastern, 5 p.m. Pacific again tomorrow night. So go have yourselves a great Wednesday. Enjoy your day. I look forward to seeing you all tomorrow. In the meantime, take care. God bless.